Miss Hurst, you are the host now.
Okay, thank you, Miss Anna.
See you.
Okay, bye. Good morning.
Unmute. Good morning, hearing examiner.
Good morning, Miss Hardy.
Good morning.
Thought maybe you'd run away.
No, never.
That was us. We ran away.
It was Mr. Moss and Mr. Stewart show yesterday.
I know. I'm back
We know
today.
who Christian Rice is?
He is, I believe, works with Mr. McMillan for Occidental.
Oh, that's right. Okay. We are live streaming already. I guess I should put a different picture up, just in case the background shows again. Been concentrating on trying to get the Dropbox situated. And I think I've got it. Knock. I'm also going to try the standing desk today. We'll see how that goes.
Good morning, Commissioner.
Mr. Chair?
Good morning, good morning, good morning.
Good morning.
I'm going all millennial today and got my ring light.
Oh, excellent. Well, I was just saying I'm going to try this standing desk thing today.
Ah,
See how that goes.
yeah.
Can't say I've used it much, but I know others do. I've even seen a commercial where I think someone has a treadmill. Although I think that would be too distracting, you know. Yeah, probably not. Okay.
Good morning, Madam Hearing Examiner. This is Josh Smith.
Good morning, Mr. Smith.
Good morning. Before we get started and when we get on the record, I did.
Hey,
confirm,
you are live streaming.
Yep, I did.
Okay.
I did confer with SPS attorneys briefly, and I think we may have a proposal that could resolve the confidential issues.
Okay.
For you, and so we can take that up whenever you'd like.
Okay. We can discuss that when we go on the record. I'll just make a note that that's a procedural issue that we need to deal with.
Great, thank you.
Thank you. And just to let you know, Mr. Smith and Mr. I don't see Mr. Marks yet. Am I going to see him? Oh, there he is. Choom, choom. Based upon the information yesterday, we will be starting with Ms. Glick this morning after we take care of any procedural items that we need to. For
Thank you, hearing examiner.
Yeah,
For-
thank you.
and well, also thank Ms. Crane. Basically, I've tried to ascertain the time frame after we recessed yesterday, the time frame necessary for questions in order to accommodate the commissioners' schedules and the witnesses' schedules, and I believe we can accomplish the questions and not be constrained.
Thank you very much. And thank you, Commissioner.
Don't see Mr. Kitco yet. Are we going to have any other? Are you going to be prepared, Ms. Hardy, to stipulate in the witnesses from yesterday?
Yes, I will, Your Honor. And I also had one procedural matter regarding exhibits that I wanted to discuss.
Okay. I just kind of want to make sure I don't lose track of those stipulated witnesses. So I kind of want to tidy that up from yesterday.
Yes.
So that we can proceed today with not having those issues. Okay, we've got about 4 minutes. Anything else that people want to discuss once we get on the record? No. Okay. The plan, I believe, is we'll get the discuss our procedural issues. We'll get our stipulated testimony in. We'll have Sierra Club offer Ms. Glick. There'll be some questions for Ms. Glick. Then we'll have the Attorney General offer Ms. Crane. And then it's my understanding we will go back to SPS witness Miranda,
That's correct.
because Mr. Meeks is not available until next week. And then after that would be Mr. Ripperger.
That's correct.
Okay. Ms. Hardy, how do you pronounce witness Miranda's first name?
Renee.
just an alternative spelling that I was not used to seeing. So thank you.
Sure.
I don't know that I'm going to have questions for witness Ripperger, who is sponsoring the line loss study, but I will confer with the commissioners to see if they have questions or not. I do not believe that any.
I gotta go, buddy.
Good morning, Mr. Lee.
Good morning, Judge. How are you?
I'm well. How about yourself?
Good.
I think you must have worked all night to get that transcript up.
I've been busy.
I think you have. I kind of envision that you have like little helpers.
I do. I have minions, as they're called.
Like oh, they're not elves anymore. That's probably not the correct. That's probably not the correct word to use anymore. Good that you have minions. Would you loan me some?
You bet.
Okay, well, it looks like we have arrived at 9 o'clock. I think where I was that I'll try to ascertain if there's any studies or any questions on the line loss study. I think I understand SPS witness Ripperger's testimony, but that's a to be decided question. And I just have a few questions for witness Miranda. Okay, well, if everyone is ready, good morning. We are live streaming and we are returning from our evening recess for day 3 of our hearing in case number 22-00286 in the matter of SPS's request to revise its rates and for determination on certain other abandonment and plant extension and or shortening information. We've had a brief discussion off the record regarding procedural matters, and I believe we have a procedural matter from Sierra Club that they wish to discuss.
Yes, thank you, Madam Hearing Examiner. This is Joshua Smith on behalf of Sierra Club. As we discussed in the first day of the hearing, there are some confidential pages for Ms. Debbie Glick's testimony. And we had gone back and forth about those a little bit. I conferred with SPS and briefly, and I believe they're amenable to this process. And essentially, we would be willing to withdraw those confidential pages, the confidential version of Ms. Glick's testimony, contingent upon the commission's acceptance of the stipulation. And should the commission reject or modify the stipulation, we would reserve our right to seek admission of that confidential version of the testimony. If that's acceptable to you, we will withdraw that confidential version.
I would, for the record, my understanding and what has been submitted to me for an in-camera inspection by SPS and has tentatively been marked as Sierra Club Exhibit 2 is a 6-page document, and that does not include the certificate of service. But essentially this purported claimed by SPS to be confidential information. The Sierra Club 2 is a document that I received that has a cover page, and it contains unredacted pages 16, 17, 18, 21, and 23 of Ms. Glick's testimony. As indicated, the parties have asserted that the document is confidential, and there was a notice of intent filed by Sierra Club to use this, and a request by SPS to determine that the information should not be disclosed. And I have taken that under advisement. When the hearing first began on Tuesday, I asked Sierra Club about whether or not they were amenable to withdrawing the confidential information, because quite frankly, since Ms. Glick did not file testimony in support of the stipulation, but Sierra Club is a signatory on the stipulation, I wanted to try to ascertain their position on Sierra Club Exhibit 2. Having confidential information or claimed confidential information in a hearing makes it much more difficult to keep an open and transparent hearing on the evidence, because if information is deemed confidential, then only persons who have signed the under the protective order, only persons who've signed the confidentiality agreement have access to that information. That would cause administrative difficulties with shutting down the streaming, eliminating anyone from the hearing that has not signed said document, except for those who are not required to sign the document, like the hearing examiner or the commissioners. With that being said, I was advised yesterday, right before evening, before we recessed, by Sierra Club Council that they'd had a change of position and now wished to offer the testimony. It now appears they've now changed back potentially to their original position with a clarification in that they're willing to withdraw the testimony. However, they have requested or not waiving the opportunity to offer the testimony should it be needed subsequent to a determination by the commission that they find not favorable to their position, is how I'm interpreting what you've said, Mr. Smith. The only, and there's an indication that SPS is amenable to this compromise position. The only change that I would make at this point Mr. Smith is and I guess there would have to be I have to think about it, but I think the cleanest way to do this is for you to withdraw it and withdraw it subject to being able to refile it. If you find it to be appropriate for any use later on in the proceeding. And what that would entail is if you agree to withdraw it and there's no objection, then I will facilitate, subject to approval of SPS, I will facilitate either the document being destroyed or arrange for a time and date for Mr. Marks to pick up the envelope, the sealed envelope that contains the confidential information. I think that would be a cleaner way to handle it. What is that? Is that having the document returned upon agreement of the parties between or the agreement of Sierra Club to withdraw the exhibit, subject to being able to refile should it become necessary. Is that acceptable, Mr. Marks, Mr. Smith, Ms. Sir?
Yeah, yes, Madam Hearing Examiner. This is Joshua Smith. Yeah, that's acceptable to us.
Ms. Hardy, does that suffice SPS's concerns regarding the treatment of this proposed confidential information?
Yes, it does, Your Honor.
Okay, Mr. Marks, would you prefer that I communicate with Ms. Sandoval, our Records Bureau Chief, to have the document destroyed, or would you like to pick it up?
So if we allow Ms. Sandoval to destroy it and this case winds up going to a litigated hearing, we could just recreate it.
Yes, sir.
Let's just do that.
Okay. All right. Very well. Then I will take it upon myself to communicate with Ms. Sandoval, the Records Bureau Chief, and tell her that Sierra Club has made a motion to withdraw this, and that she can locate the document. It's going to have to come from some warehouse, and she can notify me when it comes back, and I will make sure that the document gets destroyed. Okay. Very well. Anything further? So I'm granting the motion to withdraw. Is there any, I guess I should ask, does any party have an objection to the procedure that's been elaborated on the record? Hearing no objection, I'm going to grant Sierra Club's motion to withdraw SC2, the purported confidential document. I will request that it be returned to the building and will oversee the destruction of the document. All of this is subject to refiling should it become necessary. Anything else from Sierra Club?
No, thank you.
No. All right, very well.
Looks like the hearing examiner is frozen.
Going off the record.
I need to send some minions over to shake.
Judge, Judge, you're on mute.
Looks like the gremlins are back. I lost everybody.
I blanked out too, Madam Hearing Examiner. I'm going to switch to my Wi-Fi hotspot and hopefully that's more reliable.
Okay. Perhaps Mr. Begecko, are you here in the building?
Yes.
Do you know if any of your witnesses are here?
I believe they are all operating remotely today, watching on
Okay.
YouTube.
All right, I'll try to find somebody in the building that can go down and see who's in IT that might be able to help us.
If you'd like, I can text Phil as a starting point and maybe get the ball rolling.
That'd be great. Thank you so
All right.
much.
No problem.
Okay, so it wasn't Miss Hardy who was frozen, it was myself. Go ahead, Miss Hardy, you have a procedural matter?
I do, thank you. On our exhibits, I know we had briefly discussed at the pre-hearing conference the fact that we have several native spreadsheets primarily that are attached to our witnesses' testimony. And those have been provided via the share file site that we use, but we had not uploaded into Dropbox those native files. And I wanted to inquire whether you wanted us to do that. I believe in the last case, we had not done that, but I didn't know if the commission in your honor would prefer that we go ahead and do that.
So are you talking like work papers or?
Some of them are work papers, but most of them are attachments to testimony that we provided electronically. They just weren't, the testimony that's uploaded into Dropbox for those has slip sheets indicating that there are native attachments. And they were provided on share file, but not via Dropbox. Like, for example, the cost of service model is one, things like that.
Okay.
The very large electronic files.
Yeah, let me think about it, but my initial inclination is no.
Okay.
I mean, I don't know if the commission has a limit. I was worried about the Dropbox limit with everything that was being filed, but we have a more than the free account, so I think we're okay on that. But I don't want to, I don't want to test the limits at this point. Should it become necessary, I'll revisit this, but no.
Okay, thank you.
Go ahead. All right, do we have anything else procedural from the parties? Hearing nothing, I believe, Ms. Hardy, we're going to stipulate the testimony of some SPS witnesses.
That's correct, Your Honor.
And I believe we're gonna start with Mr. Watson.
That's correct. We have Mr. Watson's direct testimony, which is
Okay,
exhibit.
let me just, hang on, let me. Okay. Go ahead.
Exhibit SPS 28 is the direct testimony of Dane A. Watson. And exhibit SPS 29 is the rebuttal testimony of Dane A. Watson. And both
Okay,
of
hang
those.
on.
Oh, sure.
Hang on one sec. And 29 was rebuttal or supplemental?
It is rebuttal.
Okay. So I see SPS Exhibit 28, the direct testimony that was placed into the Dropbox. And you're indicating to me that this particular testimony meets all of the requirements to be stipulated in. Is that correct?
That's correct.
And it appears that SPS Exhibit 28 is a document of 132 pages that was placed into trying to figure out, this has a different screen. I'll just say it is that I have the document in Dropbox because I'm not sure if it's 271 pages. My understanding that Mr. Watson had attachments to his testimony.
He does.
And that included in attachment DAW-2 SPS's depreciation study, depreciation accrual rate study. Is that correct?
That's correct.
Okay, very well. Any objection to what's been identified as SPS Exhibit 28, Mr. Watson's direct testimony as verified as meeting the stipulation requirements and which was placed in the Dropbox as SPS Exhibit 28. Hearing no objection, SPS Exhibit 28 will be admitted. SPS Exhibit 29. Okay, I see what it's doing. That document was 271 pages.
That's correct.
SPS Exhibit 29, the rebuttal testimony of Mr. Watson also meets the requirements for stipulating in the testimony as being complete, verified by the witness, and containing accurate and or corrected information. Is that right, Ms. Hardy?
That's correct.
Okay, SPS Exhibit 29 was downloaded into Dropbox. It is a document of 160 pages. Are there any objections to admitting SPS 29? Hearing none, SPS 29 is admitted.
Thank you.
And the appearance for any more testimony for Mr. Watson?
No.
No. And there were no examination questions or cross-examination questions for Mr. Watson, and his appearance is waived. Okay, go ahead.
Thank you. The next exhibits are for Michael O. Remington. And those exhibits include SPS Exhibit 33, the direct testimony of Michael O. Remington, SPS Exhibit 34, the supplemental testimony of Michael O. Remington, and Exhibit SPS 35, the rebuttal testimony of Michael O. Remington. And those three documents meet the criteria for the submission of stipulated testimony.
Very well. SPS Exhibit 33. Mr. Remington's testimony of 158 pages was placed into the Dropbox. It's been verified that the testimony meets requirements to be stipulated into the record. Is there any objection to SPS Exhibit 33? Hearing no objection, SPS Exhibit 33 is admitted. SPS Exhibit 34 is Mr. Remington's supplemental testimony placed in the Dropbox, a document 36 pages, which has been verified as meeting stipulation admission requirements. Any objection to SPS 34? Hearing none, SPS 34 is admitted. Any objection to what has been identified as SPS Exhibit 35, which is Mr. Remington's rebuttal testimony? A document placed in the Dropbox of 20 pages, verified to meet the stipulation requirements to be admitted. Any objection? Hearing no objection, SPS 35 is admitted. Any further testimony from Mr. Remington, Ms. Hardy?
No, that is it, Your Honor.
There being no cross-examination scheduled or examination for Mr. Remington, Mr. Remington's appearance at this time is waived.
Thank you.
Anything further? Ms. Hardy?
No, Your Honor, I would be happy to stipulate in Mr. Ripperger's testimony later today, should Your Honor determine that his appearance is unnecessary.
Okay, very well. Thank you. All right, in order to accommodate witnesses, we are going to go out of our witness order at this point, and upon the non-objection of the parties, we're going to hear from Ms. Glick. And so Mr. Smith or Mr. Marks or Ms. Zer, whoever's presenting the witness, please go ahead.
Okay.
Guess we have to get the witness. Let's
Yeah,
see. Don't see her yet.
She should be joining the
There she is.
Great.
There you are. Good morning, Ms. Glick.
Good morning.
Mr. Lee, would you swear the witness, please?
Yes, Your Honor. Ms. Glick, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, ma'am.
Thank you, Mr. Lee. Go ahead, Mr. Smith.
Thank you, Madam Hearing Examiner. This is Joshua Smith on behalf of Sierra Club. Ms. Glick, will you please state your full name again for the record?
Debbie Glick.
And who are you employed by and in what capacity?
I'm employed by Synapse Energy Economics. I am a senior principal.
And who are you appearing on behalf of in this proceeding?
I am appearing on behalf of Sierra Club.
Okay. Do you have in front of you the document that was placed in the Dropbox for this case, the document marked Exhibit SC1?
Yes, I do.
And can you identify that document?
That is the public version of my direct testimony and the accompanying exhibits.
Okay. And was that testimony and the accompanying exhibits, was it prepared by you or collected by you or under your direction?
Yes, it was.
And to the best of your knowledge, is Exhibit SC1 a true and correct copy of the public testimony and exhibits you filed in this case?
Yes, it is.
And if I asked you the questions today that are asked in Exhibit SC1, would your answers and recommendations be the same as what appear in SC1?
Yes, they would.
With that, Madam Hearing Examiner, Sierra Club moves for the admission of Exhibit SC1.
Ms. Glick, there's certain information contained on pages 16, 17, 18, 21, and 23 of your SC1 that shows like little gray blacked out boxes. That indicates a number that you filed that SPS claimed was confidential information that was provided to you.
Yes, that's correct.
And but you were able in your testimony, even though you respected that claim and you eliminated the specific number from being viewed, your testimony is able to convey your conclusions on utilizing that information.
Yes, my testimony is able to convey the trends and the general information without disclosing specific confidential numbers.
Thank you. Any objection to what's been identified as Sierra Club Exhibit 1, the pre-filed direct testimony of Ms. Glick as verified by her here today? Hearing no objection, Sierra Club Exhibit 1 is admitted. Mr. Smith?
Thank you, Madam Hearing Examiner. I would tender Ms. Glick for cross-examination at this time.
Very well. I believe that according to the pre-hearing memos, the only party to schedule time for cross-examination for Ms. Glick is you, Ms. Lynch, and I believe you scheduled 20 minutes. Is that correct?
That is correct.
Would you like to begin?
Yes, please. Good morning, Ms. Glick. It's nice to see you.
Good morning, Ms. Lynch.
As you know, I'm the attorney for Coalition for Clean and Affordable Energy. I just have a few questions for you about the analysis that you conducted here on the information that SPS provided. To begin, in your testimony for this matter, you provide analysis of the models used by SPS, correct?
That is correct.
Okay. And in that, in looking at that information, do any of the scenarios modeled by SPS include NOx allowance costs?
Just to clarify, you're talking about the Encompass model scenarios?
Yes.
I do not believe that NOx costs were included because the prior NOx costs were capped. So the company did not include NOx emissions costs in the Encompass modeling.
Based upon that, that information that the NOx allowance costs were not included, do you have any of your own conclusions on that modeling regarding the NOx costs? What influence would that have for them not to include NOx allowance costs?
So I can more easily answer the question, what impact would it have if NOx costs were included? Is that acceptable?
Sure.
Okay, so if NOx costs are included, they should be modeled as a dispatch adder. So it's essentially a cost that would be incurred when the plants are utilized. So especially if the company exceeds its summer allowance, so the NOx cost might not be included for when the unit is under the cap, but once it exceeds the cap. And that should increase the cost to dispatch and operate the plant once it goes above a certain number of megawatt hours that exceeds the NOx emissions cap. So that would increase the cost to operate the plant when it's operating on coal, which would therefore send a message back to the company that it's too expensive to operate the plant on coal, and therefore they would reduce the output. The company would likely choose, if they're economically committing the unit, to reduce how much it's operated, because they would be receiving the economic signal that it is more expensive with the NOx credits, NOx costs rather.
Thanks. Thank you for that description. So now we're going to move on to a question that examines the CO2 emissions. Can you confirm, based upon your analysis, that cumulative CO2 emissions are the same for the higher generation, earlier retirement scenario, and the lower generation, later retirement scenario? So the 2028 and 2032 scenarios.
I looked at the math and I believe they are 0.05 or 0.5% higher under the early retirement scenario. So very, very minimally different. And the difference is really just a result of which replacement resources the company brought online. So the emissions are essentially the same, because the total megawatt hours or gigawatt hours from the coal plant are the same.
Thank you. Are you at all concerned that SPS plans are based upon an optimization of fossil fuel prices rather than accelerating a shift from fossil fuel generation to clean energy?
Sorry, I'm not entirely clear on what that question is asking. Would you mind rephrasing?
Yep. Are you concerned at all that the plans presented by SPS means that they would be optimizing the use of fossil fuels rather than accelerating a shift from fossil fuel generation to clean energy? Meaning, was any clean energy or renewable energy modeled in these scenarios?
So the Encompass model is an optimization tool, and so SPS offered in renewable replacement resources as an option, and the model did select renewable resources to be built out over the course of the modeling period. So I'm not entirely sure. I don't think I quite understand what you're asking. I'd be happy to try again if you could rephrase it.
I think we might come back to that in just a minute,
Sure.
because it's complicated and technical information. So based upon your analysis, can you confirm that recent renewable energy prices are better than prices for Tolk at its highest generation of 4,000 gigawatt hours per day?
So there are many different ways to measure economics. There could be the energy cost, the capital cost. You have to look at the cost of an entire replacement portfolio. So my analysis showed that it is more economic to replace. It is likely more economic to replace Tolk with clean energy resources than to keep it online, just based on the levelized cost of energy and the likely cost of keeping Tolk online. Unfortunately, I did not do my own Encompass modeling, so I didn't, test a specific portfolio, but based on the levelized cost of keeping Tolk online and the levelized cost and capital cost of renewables, I find it's very, very likely that it is lower cost to replace Tolk as soon as possible, which is why the Sierra Club supports the retirement of Tolk in 2028 per the stipulation.
Okay. Let's see. I need to just navigate to your direct testimony, because I think that might help clarify that question that I was having, that I was struggling to ask. Shoot.
And my computer has frozen. If you could turn to your direct testimony, page 30.
Yes, give me 1 second to navigate there.
Somebody needs to go on mute, whoever has the background voices in the background.
Unfortunately, that's me because I share an office. So I will try to mute myself when I'm not speaking.
Thank you.
Ms. Lynch, this is Josh Smith at Sierra Club. Could you clarify, are you referring to page 30 of the Bates stamp pages, 30 of 133 at the top left corner, or are you referring to page 30 at the bottom as initially paginated?
You're muted.
Let me confirm that. My Adobe Acrobat has frozen, so I'm trying to figure out how to navigate this situation right now, which is a little bit stressful. So I apologize for this occurring. It would be in the initial pagination. Does that help?
Yes.
Okay.
Is it the page that starts with the Q? Do you have any concerns with the assumptions?
Let me confirm that. Yes.
Great, I'm there.
Could you read the question and your response for us, please?
Yes, you want the entire response? It goes on for a page and a half.
Just probably the relevant paragraph.
Okay. The question, do you have any concerns with the assumptions or results of SPS's 2022 talc analysis? Answer, I am concerned that SPS has been focusing and continues to focus its talc analysis on which fossil resource, coal or gas, is the most expensive at the moment, instead of focusing on how it can accelerate the retirement of talc and replace it with low carbon alternatives. By focusing on this short-term dynamic, SPS has now all but locked itself into reliance on talc and volatile fossil fuels for several more years as it procures new resources. SPS should focus on procuring replacement resources, and in the interim, SPS should seek to minimize operations at the plant to conserve water, reduce emissions and costs, and preserve optionality. Would you like me to keep going, Ms. Lynch?
No, that's fine. I just wanted to clarify what was meant when you answered the question above. And so I think, you know, that's appropriate for what I was trying to ask when speaking about the optimization of fossil fuel prices rather than accelerating a shift.
Is that a question?
Well, I'm just clarifying because this has been botched. I am really sorry. So in your assessment, you're suggesting that the SPS should shift to renewable energy sooner, correct?
My assessment based on the economics of talc and of replacement resources is that it's in the best interest of the company to shift to renewables.
Thank you. Those are all my questions for you at this time, Ms. Glick. I really appreciate that you could be here today to answer these.
Thank you, Ms. Lynch.
Yep.
Thank you.
Thank you.
Just trying to, okay, turn off the timer. Very well. I just have a few questions. I think I understand your testimony. I guess just generally, Ms. Glick, based upon your interest in filing direct testimony in this case, I was kind of surprised. You didn't file testimony in support of the stipulation, did you?
I did not.
Why?
That's a decision for the Sierra Club.
Okay. So I shouldn't take it as an indication that you're not in agreement with the stipulation, should I?
No, that has nothing to do with my agreement with the stipulation. My client is Sierra Club, and they are the ones that decide where and when to file testimony.
And so you do agree with the stipulation then?
As an expert, I believe that the stipulation, which supports the retirement of Tolk in 2028 and which puts forward economic operation of Tolk prior to its retirement, is a reasonable and a good compromise, which will limit the operation of the plant when it is operated and dispatched based on economics.
Well, just generally, what is, as far as your assignment and responsibility, is trying to accomplish what goals?
To perform economic analysis of the Tolk power plant and of alternative renewable and other types of resources, and to evaluate the risks of relying on different resources.
So it's not just necessarily the focus is on pursuing renewable energy options, but it's also evaluating the costs for the particular generation and any replacement.
Yes.
Is that correct?
Yeah, I am an expert in economics and in policy and in evaluating risk, and so that is my job and goal in this case, is to focus on the economics and on the risks.
Okay, and I thought I heard you say in response to one of Ms. Lynch's questions that as far as the emissions, that they're pretty equivalent whether Tolk changes its operation plan to retire in 2028, or if it remained on its current plan and didn't retire until 2032. Is that correct?
So based on the company's modeling results, the emissions are identical. But just to clarify, it is my belief and understanding as an expert that if the plant is operated economically with the significantly lower gas prices that we now see, it naturally will be operated less than the modeled 4,000 gigawatt hours. And therefore, the emissions in reality, I expect to actually be less under a 2028 retirement, because it doesn't appear to me that it would economically operate that way. So this is a distinction between the company's theoretical modeling, which relies on gas price assumptions that already are out of date, and then my expert understanding of what's likely to actually materialize based on current trends.
Okay. Additionally, I thought it was your testimony in response to another question by Ms. Lynch that one of the reasons that Sierra Club is supporting the stipulation, or that you are supporting the stipulation, is because it's shortening the time that Tolk would be operating, and be able to be replaced by cheaper renewable resources. Was that your testimony?
Mike, so what I was stating that was that the Sierra Club supports the stipulation in large part because it locks in a retirement date in 2028. And it's my opinion that retiring the plant earlier reduces costs and reduces risks relating to water availability, relating to continued reliance on a fossil resource.
Okay. So some of the criticisms that you had in your testimony. So for example, I'm looking at page 11 of your direct testimony. And you're answering the question posed on page 10 at line 14. What else is SPS requesting in this rate case related to the Tolk power plant? And you begin your answer at line 15. And you're talking about incremental costs. And on page 11, you say at line 3, SPS states it's requesting this special rate treatment.
I'm sorry, Judge, can you start again? SPS
states that it is requesting this special rate treatment because dispatching Tolk in a flexible manner causes significant variability in the O&M costs associated with the operation of units. The request concerns me because SPS is not aligning its cost of service calculations with its operational planning. That was your testimony?
Yes, so that is in relation to the SPS's request to recover O&M through a regulatory asset, which has been withdrawn. So I believe that Q&A is not relevant to anything that's in the current request.
So basically the agreement, the stipulation included other things other than just the early termination of Tolk, but also this other request that's now, you believe, rendered moot because of the stipulation, correct?
Correct. My understanding is the stipulation, in the stipulation, there is an agreement for a O&M to be based on the 4,000 gigawatt hour operational assumption.
Okay. And I'm going to be careful. I have a question about page 18. And on page 18, the question posed at lines 1 and 2, how does the cost to operate Tolk compare with the cost of alternative resources in the region? And part of the non-confidential answer was at the bottom of that Q&A with regard to Tucson Electric Power Company. You included that in your testimony?
That's correct.
About their kilowatt cost for a wind project?
That's correct.
Why did you think that particular cost was relevant to the information that SPS had included?
So that cost is just one of many. So if you scroll to the next 2 pages, there's several tables. So I didn't include a table for a single wind project, but I was trying to basically just present a full picture of what are the costs of wind projects, of solar and battery storage projects, just to provide the commission with context and information on what other renewable projects are the cost at which other renewable projects and battery storage projects are being built in the region. I think it's relevant for a comparator to understand how much does it cost on an ongoing basis to operate Tolk relative to how much does it cost to build and operate wind projects, solar and battery storage projects, reasonable replacement resources.
And have all of the projects that you've listed in your table 7 and table 8 on your pages 19 and 20 of your testimony, have all of those projects been approved?
They have all, I believe they have all received approval, subject to check by the commissions. Several of them were in the process of receiving approval, and I believe that they have now all received final approval, but that'll be subject to check.
And I guess I just wonder whether or not Mr. Smith, make that a bench request. That I would like to know specifically if the reference resources in those tables have been approved by the relevant jurisdictions.
Yes, Your Honor.
And just to clarify, in some states there is no pre-approval. So what kind of response would you like in those instances?
Not required.
Like Arizona doesn't require pre-approval of.
Oh, okay. But when looking at the projects, I noticed that you did not include Hale or Sagamore. Are you familiar with Hale and Sagamore?
Those are already online, I understand.
Okay. So you're saying, oh, and these are all, well, table 7 says recent solar PV and wind PPAs, correct?
Correct. I was trying to show ones that are relatively recent. It wasn't I didn't have a firm cutoff date. I don't recall, I can go back and look when the PPAs or the RFPs for Hale and Sagamore were issued. I think I was trying to do a cutoff around 2020 or so to just look at recent ones. So I would think those projects were solicited prior to 2020, but I'd have to go and check. I was just trying to do cost estimates that were relatively current and helpful for thinking about a replacement resource moving forward.
And just to clarify for the record, table 8 is recent solar PV and battery energy storage system projects. And the only thing I can tell you is they were approved. They were in a filed 17 case. Mm-hmm. The first one was put through in a rate case 19-170. The second was put through in the last rate case 20-238. So the last one may have actually met your 20, or it could have been 19. Okay. All right. Well, you've answered my question of where did that come from and why was that included? I had a question on page 23 of your testimony. The question posed at line 3, what costs would SPS avoid?
1 second to navigate to there so I can follow along?
Sure.
Thank you.
And Madam Hearing Examiner, this is Josh Smith. Just for clarity, are you referring to 23 at the bottom of the page?
I am. Okay. I always refer to the to what the witness claimed was the page number and not the PDF.
Okay, thank you. Just wanted to follow.
Yeah, too confusing.
23 or 33? I'm sorry. I think I just heard
23.
23. Okay, I'm on 23. Yes.
Okay. So the question posed at line 3, what cost would SPS avoid by retiring Tolk in 2028 rather than in 2032? So you're referencing between line 7 and 11, you're referencing risks, and then you give an example beginning on line 11. SPS's current analysis does not include the costs associated with the good neighbor rule compliance which the EPA just finalized. As I later discussed, compliance with the Good Neighbor rule will require either operation at very low levels, investment in costly environmental upgrades, or else the purchase of expensive NOx emission credits. That's your testimony?
That's correct.
I've heard testimony already this week that that rule is stayed in a Fifth Circuit Court of Appeals case that SPS is involved in. Are you aware of that?
Yes.
Did you happen to listen to any of the hearing earlier when the witness might have been witness Trammell? When I was asking about that and asking potentially how long that could be, did you hear any of that?
I listened to part of it, but I don't recall that part. No.
Well, do you have familiarity with environmental regulation litigation?
I'm not a lawyer, so my experience with it is generally just in providing expert witness testimony, and in the Sierra Club or the other lawyers I work with generally will inform me about relevant proceedings, but I wouldn't claim to be an expert in the legal component.
Well, and all I'm asking you isn't about the legal component. I'm just asking you generally if you know how long those cases can take.
No, ma'am.
Okay, because it kind of seemed like to me that having some familiarity, not specifically with environmental cases, but just civil cases, can last many years. And I'm just wondering if actually, and I believe I asked the SPS witness, if it actually might be cheaper to continue to litigate this until after 2028, rather than have the potential environmental compliance costs. But I believe that the witness's testimony was that that SPS was actually in some kind of negative situation.
I was not listening. From my perspective, generally, well, it could take a long time. It's also a risk. So uncertainty about how a regulation will pan out also creates a risk, and sometimes planning, assuming that the regulation is finalized, can be cheaper or a more preferable alternative to the uncertainty of not knowing. So I think from my perspective, as I discussed, I'm evaluating the risk. And there's a risk to not planning and not acting, and then a regulation is finalized and the company hasn't planned and hasn't acted. And so from my perspective, it's more prudent action to plan as though it would be finalized and figure out the lowest cost or least regrets option.
Do you do testimony on return on equity and cost of capital also and evaluate risk?
No.
That
is not within my area of expertise.
Okay. I've already heard about risk this week in that particular juncture. Okay, and then on page 26 of your direct testimony, you're characterizing SPS's findings, correct?
Let me just quickly scan this page and see what it's discussing.
Okay, and I'm specifically looking at your lines 15 through 17 on page 26. Your answer.
Yes. Yes, this is discussing the TOLC analysis, the 2022 TOLC analysis the company conducted.
Yeah. And you say beginning at end of line 15. In other words, SBS wants to ramp up the operations of Tolk and use up a substantial portion of Tolk's remaining water while gas prices are high. Correct?
Yes, that is what I say on lines 15 through 17.
Do you agree with it?
So that is my assessment of what the company is doing it's looking at that's what the model was doing in the Encompass modeling. It was looking at the high gas prices and ramping up operation of the coal plant while the gas prices were high, and therefore utilizing the remaining water.
And that's the most economic thing to do, correct?
So that was what the model said was most economic based on the high gas price inputs the company had provided.
Which you think perhaps is modified by current events based on your testimony here this morning.
Yes, I believe I could have to look what page it's on. I believe I include in my testimony some graphs on the difference between the gas prices that SPS utilized and the company's even current gas price forecast. If you go down to
page 40 and 41.
Yeah, well, 39 also. Yeah, exactly. So, it's not just my opinion. It's, even the company's own forecasts that were produced more currently show a deviation. And I would guess that the forecast the company is using in its current IRP process do show significantly lower gas price forecasts.
Okay. I had a concern with some testimony on page 31, and you're answering the question posed on line 30. Do you have any concerns with the assumptions or results of SPS's 2022 Tolk analysis? And on page 31, you're still answering that questions. And at lines 6 through 8, you conclude SPS is therefore planning to acquire new resources, which will become stranded assets 2/3 of the way through their initial useful lives. Is that correct?
Yes, that's correct.
So that particular conclusion is based on the fact that you believe that they're adding generation, carbon producing generation? I mean, that they're going to add more gas, or does this also, do you think that some of the renewable generation is also going to be stranded?
No, so this is based on I just looked at the company's results from the Encompass modeling, and when Tolk is retired in both scenarios, the Encompass model builds about 900 megawatts of new gas capacity to replace Tolk. And given I'm trying to scroll down to where is this, given the New Mexico statute that requires utilities to be carbon free by 2045, if you're building get new gas plant with a 30-year lifetime in 2028 or 2032, that asset will be online beyond 2045. And unless you convert it to somehow be a carbon-free resource, it will become a stranded asset because it can no longer operate as a carbon-emitting resource beyond 2045.
But were you given any information of any current or pending approvals that the company has asked for to build more gas?
No, so the company's modeling results showed a build out of new gas. So this statement is based on just looking at the modeling results the company entered into the record that showed the Tolk plant being replaced by new gas. If that's not what the company actually ends up proposing, that's great. But I was concerned because then therefore, if the modeling is not accurate with what the company is proposing, then that would be something just to think about, what is the point of the modeling if it's relying on resources the company has no plan to actually build.
Well, and it's not just the type of resource, but on page 33, you're answering the question posed on page 32, based on SPS's modeling. Can you project what it would look like for TOLC to operate with reduced annual operations in line with current TOLC optimization plans and retire at the end of 2028? And on page 33, beginning at line 11, he said, but these results are outdated and likely overstate the cost of this scenario. Specifically, with updated natural gas prices, NOx emission costs, and other environmental compliance costs included, that cost difference should drop significantly and will likely be eliminated. Right?
Yeah, that's what it says.
So it doesn't sound like you're real happy with modeling.
So the modeling is not updated, and it's not, that's, I assume the company is doing updated modeling for the IRP. Yes, I did have many critiques of the modeling and the modeling results.
Okay. I have one other question, and it relates to page 41 of your testimony. And the question posed at line 4 and 5, how does the IRA change the tax credits available to SPS for clean energy resources? And so I think I guess I have two questions. Your testimony ends on page 42 and lines 1 through 3 says, if SPS cites new renewables at the TOLC plant, it should qualify for the energy community adder, but it is not clear that the company included this assumption in its modeling. That's your testimony?
Yes, that's correct.
And what would the effect of qualifying for that new energy adder result in?
It would further reduce the cost of building new solar and new renewables, because they would qualify for essentially an additional tax credit.
And I seem to have heard some testimony earlier, and as part of, I believe, Ms. Trammell's testimony, that in trying to quantify now from where the case was to the stipulation and what SPS is still asking for in addition to the stipulation, there seemed to be, or what I interpreted was that SPS is already not using the production tax credits that it has. Do you know that, if that's correct?
I do not know. I don't know how SPS uses its tax credits.
Because there seemed to be a request that if there was some way to monetize them, I don't know that there's a market, but that and that could have been with Miss Martin. Anyway, that if there was a chance to monetize these production tax credits that SPS currently was not able to use, then potentially that also could be a reduction to the cost that the ratepayers are paying, wouldn't it?
Yeah, so if SPS doesn't have a big enough tax appetite, they can buy renewables through a power purchase agreement from a company that does. It's also my understanding that the IRA includes a provision to allow tax credits to be, there to be a market to buy and sell the extra tax credits if a company cannot fully monetize them. So it's I don't know if that's been clarified and how that would happen yet, but it's my understanding that going forward, that should be less of an issue.
I thank you, Ms. Glick. That's all the questions that I had for you. Chairman,
Thank you.
I believe that you might have some questions for Ms. Glick.
Yeah, I have two. Thank you. Morning, Ms. Glick.
Good morning.
Could you turn to bottom of the page number, let's say 48?
Yes, I'm on 48.
And so really my question is keyed to the number that's the first number on page 49, $48,000 a short ton for NOx allowances. So do you know how volatile NOx allowance prices are?
I do not know.
Okay. And then do you know if the allowance prices are correlated to natural gas prices?
I don't know. I believe they're based on the quantity of NOx emissions that are being emitted by other generators in the region.
Yeah, I was just curious that, what we're looking at now is a trade of coal for gas. Does that have an impact?
Oh, yes. Yep.
And then, real broadly, just trying to understand, is a coal plus NOx allowance dispatch cost more or less than volatile than a gas dispatch cost? So just if you have any information to enlighten me on that, I'd appreciate it.
So you're asking if it would be more volatile for a coal plant than for a gas plant with a high NOx price?
Yeah, the company's testimony is that coal prices are much more stable than gas. I'm just curious to know if you've got coal with a NOx allowance tacked on top of it, is that true?
I think if you keep your generation levels below your NOx cap, then you can maintain a pretty stable coal dispatch cost. If you're economically committing it and committing it above your cap, then I think that's where you enter volatility. I think that's why part of my testimony is recommending reduced operations, and hopefully with economic operations, it will naturally reduce how much the plant is operated, to avoid that cost, to avoid that volatility.
Yeah, I appreciate that. Thank you. And then my other question, if you could turn to the stipulation, paragraph 16.
Sorry, do we know what exhibit that is? I don't have that open. I have the Dropbox.
I will hang on just a second. I believe, whoa, went way small. Well, I can tell you the stipulation is SPS Exhibit 1.
Okay, great.
But I can try to.
SPS Exhibit 1 looks like the application.
It's Signatories Exhibit 1.
Okay.
I'm sorry.
It's okay. Yes. Okay. Yep. I've got that open.
Okay, so I'm on page number at the bottom middle of the page 8. So that's paragraph, if I'm reading my Roman numerals correctly, 16, SPS integrated resource planning process.
Yep, I see that.
Have you participated in SPS's integrated resource planning processes?
I believe the Sierra Club is going to have me be involved in a limited degree. I have not attended any of the meetings. I've had a couple conversations with Sierra Club about it. So I've been involved at a high level as an expert, but I have not been at any of the stakeholder meetings yet.
Okay, so and you're talking about the current process, right?
Yes, that's correct.
Have you participated in any historic processes?
Yes, so I did participate in the prior IRP process, I believe, and I produced a report on the Tolk analysis as part of some comments that Sierra Club submitted, I think during the 2021 IRP process.
Yeah, so then just wanted to make sure, I thought you had participated, just wanted to make sure.
Yes.
So my question, the stipulation requires SPS to provide a forum for interested stakeholders to discuss timing of replacement resources to address retirement of Tolk. So just based on your experience with SPS and its conduct of its IRP, why do you see that? Is this paragraph necessary inclusion in the stipulation?
So I'm not a lawyer, so I guess I don't know the legal reasons why. Based on the prior stakeholder process, it's and the current stakeholder process, it seems like it's occurring, but I don't know the reason why this was put in there, so I can't really comment on that.
Okay, I appreciate that answer. I mean, just when I read that, I was surprised that the IRP wouldn't be a forum for this, so it just kind of stuck out like a sore thumb. Why is this in the stipulation?
Yeah, I don't know if it's legally required or if it's just something nice they do. So I guess that I don't know if this is necessary or not.
Okay, thank you. I appreciate it. Ms. Hurst, no further questions.
Thank you, Chairman. Commissioner Aguilara, do you have questions, sir?
I do have one question.
Go ahead, sir.
Good morning, Ms. Glick.
Good morning.
Thank you for appearing and for your responses. I wanted to ask a follow-up question on one of your responses earlier. You explained that you believe that with an earlier retirement of Tolk, despite SPS's modeling that it will be used the same amount, you believe that it would actually probably be used less given economic dispatches. And so I appreciate that explanation. So I just wanted to drill down and is that belief based on just like a national, this is sort of what happens type of economic dispatch, or is it more focused to the Southwest power pool where the Tolk generator will be operating?
I'm sorry, I mean, I think it's both. So just thinking broadly about natural gas versus coal prices, when gas prices are high, coal becomes more economic and coal plant generation goes up. I think we saw that on a national scale in the past year. When gas prices go down, then coal generation goes down and gas operation goes up. I think from a regional perspective, the NOx issue is a regional issue. So the limitations, the cap on NOx is a regional issue that will impact how much the plant can operate economically before it incurs the higher NOx costs. So it's based on both national and regional trends.
Okay, thank you. And just one last question. Is there anything about the SPP market, the resources that operate there that would lead you to believe that this would be used a little bit less than, occurs nationally or a little bit more? Is there anything unique to SPP?
No, and I haven't looked at that. I don't, off the cuff, I can't say that I would have any intuition on how it would be used more or less if it was in another market relative to being in SPP.
Okay, thank you. I appreciate the responses. That is all I had, Madam Hearing Examiner. Thank you.
Thank you, Commissioner. I do not believe that there were any other cross-examination, and Commission has finished with its questions. Mr. Smith, do you have redirect for your witness?
Yeah, I'd like to ask a couple of quick follow-up clarification questions, if that's all right, Madam Hearing.
Okay, go ahead.
Thank you. Ms. Glick, do you recall some questions from the hearing examiner about the Good Neighbor Plan and the stay of the litigation, stay of that rule?
Yes, I do.
Are you aware, or regardless of the status of that litigation, the continued operation of Tolk will incur NOx costs? Isn't that correct?
Yeah, I believe so. It will continue to emit NOx emissions. Yes.
And that's because there's another regulation that continues to impose costs on the unit. Isn't that right?
Yes, I believe so.
Are you familiar with what's called CSAPR, the Cross-State Air Pollution Rule?
Yes.
And that's going to continue to impose a NOx cost regardless of the good neighbor outcome.
Yes, that's correct.
And then you also, and this is in your testimony, you speak to other environmental compliance risks associated with the continued operation of the plant. Isn't that right?
Yes, that's correct.
And one of those other risks is environmental risk associated with the regional haze rule. Is that right?
Yes, that's correct.
And that could impose additional capital costs at Tolk if it continued to operate past 2028.
Yeah, right? That's correct. Yes.
And are you familiar with EPA's proposed so-called 111D regulations?
Yes, the carbon dioxide emission regulations. Yep.
And
that 1 is that 1.11?
Apologies. It's 111D.
Thank you.
And under that regulation, there's a risk that the continued operation of the plant past 2028 would incur additional costs. Is that correct? I think.
Correct. If it retires in 2028, it would not incur additional costs. It's if it operates beyond, it could.
Okay, great.
So, Ms. Glick, are you saying then that the continued operation with the synchronous condensers wouldn't be subject to all these environmental costs that you have just testified to in response to your counsel, but also I see some of them on pages 46 and 47 of your testimony?
So when a coal plant is operating when it's being used as a synchronous condenser, the fuel source has essentially been disconnected. And so there are no emissions associated with that. So it would not be subject to CO2 emissions if it's being used as a synchronous condenser.
Or any of these other environmental regulations?
So I'm not an engineer, but it's my understanding that as a synchronous condenser, it's not emitting it's not burning fossil resources. It's not emitting emissions. It's being used as basically just to provide grid services, not generation.
Okay, thank you. Go ahead, sir.
Thank you. And then just a couple of other things here. I believe Commissioner Aguilera asked you a little bit about trends in dispatch. Do you recall that?
Yes.
In addition to local or regional and national trends, are you familiar with a provision in the stipulation that imposes some specific limitations on the operation of Tolk?
I'm not sure. Can you tell me which stipulation?
Yeah. So thank you. If you can go to section 17 of the stipulation, it's labeled, or paragraph 17, it's labeled Tolk self-commitment. Do you see that?
Yes.
Are you generally familiar with this paragraph, or what this requires?
Yes. So this is requiring that the company economically commit the unit into the SPP market and not self-committed, basically not committed when it's not economic to operate.
And how do you think this provision will affect the dispatch of Tolk?
So it should reduce the dispatch of Tolk, especially with lower gas prices. And if there are increased NOx emission costs as well, it should naturally reduce how much Tolk is economically committed, because other gas plants, other resources should be less expensive to operate than Tolk.
And would you, if that trend occurs, would you expect that to benefit customers economically?
Yes, so economic commitment should choose the resource that is lowest cost and therefore pass on to customers the lowest cost for operation.
And if the units are operating less frequently, you would expect them to be emitting less carbon dioxide. Is that correct?
Yes, that's correct.
And they would be emitting less NOx as well, nitrogen oxides. Is that correct?
Yeah, that's correct.
Thank you, Madam Hearing Examiner. Those are all the questions I have on redirect.
Very well. Any recross questions or questions based upon the commissioner's questions or my questions to Ms. Glick?
Yes.
Ms.
This
Lynch?
is Kara Lynch with CCAE. I do have one question for Ms. Glick. And that is, if you could please provide your expert opinion on some of the costs related to TOLC. Do you think that if the stipulation were modified so that TOLC were operated in the current conservation mode, which was, anyway, we all know what the current conservation mode is, would that guarantee less NOx costs for the company at this time?
Less NOx costs than economic operation?
Yes.
So it depends. Economic operation could very well reduce the costs, reduce operation below the conservation mode. It just depends.
It depends, but operating within the conservation mode would guarantee a cap, correct?
That would, yes, that's my understanding, is that that's a cap.
Okay, I appreciate it. Thank you. That's all my questions for now.
Very well. I believe if no one has any further questions for Ms. Glick, Ms. Glick, I understand you're going on a trip. I hope you have a good trip. And you're excused.
Thank you.
Just exit the Zoom. Mr. Smith, anything further from Sierra Club?
At this
time.
Thank you.
Very well. Okay. Well, I think that it's time for our morning recess. We'll come back in 10 minutes. So it's 10:30. We'll come back at 10:40. And Mr. Getko, we can then hear from Ms. Crane. We are recessed until 10:40.
Good morning, Mr. Lee. Can you hear me?
Yes, Ms. Crane, how are you today?
I'm fine, thank you.
You're on mute, Judge, unless you're on the phone.
Nope, I was saying I'm still trying to get used to the standing desk thing. I don't know if I can change horses in midstream. Maybe I can. Hello there, Miss Crane. Long time no see.
Yes, good morning, Your Honor.
I thought I thought 2238 is going to be our last go round, but both of us are back.
Hopefully we have a few more in us.
I don't know what that says about us. Awesome. Well, we're back on our back from our recess, and I have been to records, and they have requested an order for regarding Sierra Club Exhibit 2, which I will issue, which will facilitate them retrieving the documents or sealed document for destruction next week. Just want to note before we go to our next witness on the record that I put a putative commission exhibit in the Dropbox last evening after the conclusion of our hearing. And that is SPS's response to bench request 1 that was issued by the chair during the hearing. And in case parties are not riveted to the Dropbox, just wanted to let you know that that's in there. And I believe that's what I wanted to let you know. So, Mr. Gadko, I believe we are ready for your witness.
Excuse me, Madam Hearing Examiner, this is Joshua Smith. I'm sorry to interrupt. I had one quick clarifying question.
Okay.
You had a bench request during Ms. Glick's testimony, and we will try to get that to you as soon as possible. It may take a day to try to track down the different approvals. Is tomorrow?
That's fine.
Okay? Okay.
Absolutely. Okay. Thank you. Mr. Getko, go ahead.
Thank you. Good morning. The New Mexico Office of the Attorney General would like to call Andrea C. Crane.
Mr. Lee, would you swear in the witness, please?
Yes, Your Honor. Ms. Crane, would you please raise your right hand? You solemnly swear the testimony you're about to give in matter and opinion should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you, ma'am.
Good morning, Ms. Crane.
Good morning.
Could you please state and spell your name for the record?
Yes, my name is Andrea Crane, Crane.
And who do you work for and what are your duties?
I'm president of the Columbia Group, and I'm testifying today on behalf of the New Mexico Attorney General.
Okay. Do you have NMAG Exhibit 1, the direct testimony of Andrea C. Crane regarding revenue requirements in front of you?
I do.
And do you recognize that as your direct testimony in this case?
Yes, I do.
Did you prepare it?
Yes, I did.
Are there any changes or corrections you would like to make at this time?
No.
And if I asked you the same questions today under oath, would you give the same answers?
Yes, I would.
And are those answers true and correct to the best of your belief?
Yes, they are.
Madam Hearing Examiner, I request that NMAG Exhibit 1 be admitted into the record.
Ms. Crane, did you have attachments to your direct testimony filed in this case?
I do.
And they were prepared by you or under your direction and control?
They were.
Any objection to what's been identified as New Mexico Attorney General Exhibit Ms. Crane's pre-filed direct testimony as placed into the Dropbox as NMAG Exhibit 1, a document of 93 pages, as verified by Ms. Crane here today. Hearing no objection, NMAG 1 is admitted. Mr. Gecko?
Thank you, Madam Hearing Examiner. Ms. Crane, do you have what is titled as NMAG Exhibit 4, your testimony in support of contested comprehensive stipulation in front of you?
I do.
And do you recognize that as your testimony in support of contested comprehensive stipulation?
Yes, I do.
And did you prepare it?
I did.
Are there any changes or corrections you would like to make at this time?
No.
And if I asked you the same questions today under oath, would you give the same answers?
Yes, I would.
Are these answers true and correct to the best of your belief?
They are.
Madam Hearing Examiner, I request that NMAG Exhibit 4 be admitted into the record.
Any objection to what's been identified as New Mexico Attorney General Exhibit 4, Ms. Crane's testimony in support of the stipulation as verified by her here today? Hearing no objection, New Mexico Attorney General Exhibit 4 is admitted. Mr. Gecko?
Thank you, Madam Hearing Examiner. The Office of the Attorney General tenders Ms. Crane for cross-examination.
Very well. Ms. Crane, you had several. Let the record indicate, I do not believe that anybody scheduled any time for cross-examination for Ms. Crane. I believe that some of the commissioners have questions, and I have questions for you. So in lieu of not hearing from the commissioners right now, I'll go ahead. Welcome. Again, like you say, it's been a little while. The Attorney General had several through you, Dr. Woolrich, and Dr. Gigax. Had several issues with the original case as filed. Is that correct?
Yes, it is.
And I think, as generally happens in these matters, there's a difference of opinion on how much the revenue increase should be, if any, the capital structure, and the return on equity. Is that correct?
Yes, it is.
And on page 7, testimony, you start with your recommendations regarding what those changes should be, don't you?
I do.
And I guess the original request of the revenue increase, in this case, approximately $77 million, which
Yes.
was revised to 76, and then I think it was revised again to about 75. Does that sound right?
Yes, it does.
And the Attorney General's office had pretty much a vastly different idea of what the revenue increase should be, didn't it?
We did.
And as indicated on item 3 of your testimony, on item 3, line 12 on page 7, you indicate that basically there should be a $8.6 million revenue deficiency, correct?
Yes.
And part of that had to do with your characterization on page 11, answering the question posed at page 10, line 4. Are there particular challenges to reviewing a base rate case that uses a future test year? And you're telling us, beginning at line 6, yes, there are. And you say, since a future test year is based on projected cost, it's much more difficult to analyze a base rate proceeding that utilizes a future test year than a case that's based on a historical test year, correct?
Yes.
And you actually say on page 11, continuing to answer that, beginning on line 4, in this case, SPS has provided literally thousands of pages of testimony and schedules, including 3 major models. For the most part, the company's documentation presents in exhausting detail the mathematical link between the base period and the future test year. Therefore, while the numbers add up, there is often inadequate support for the underlying adjustments. That was your testimony?
It was.
And can you just explain for the commission, just give a general outline of what you mean by that and how it relates to the future test year that we have in this case?
Sure. Well, I don't know how many pages the entire filing consisted of, but I did hear earlier this morning you talk about one exhibit, which by itself was over 1,000 pages. So there were probably many thousands of pages of testimony and exhibits submitted in this case, much of which consisted of models, financial models, Excel spreadsheets, in excruciating detail. And in many cases, the company, in my view, spent quite a bit of time identifying adjustments by specific FERC accounts, and then starting with its base period and going through its linkage periods and finally into the future test year, making sure that when it added the adjustments to the base period and through the linkage periods, it would end up with the test year numbers. I think a lot of their effort was in that presentation, which frankly is not that helpful to me as a revenue requirement witness. From a revenue requirement perspective, I don't really care so much about what accounts a specific cost is booked into. In general. I mean, I certainly care whether it's capital or whether it's expense, that sort of thing. But overall, whether it's 510 or 511 really doesn't mean too much to me
I'm
as a
sorry.
revenue.
I'm sorry, is that 5.10?
No, it's 510 or 511 doesn't really mean anything to me because it's not going to change my revenue requirement. So I went through a lot of models and testimony and exhibits, trying to get behind the numbers. Okay. If the company said that the adjustment was going to be $5,000, I wanted to know not just that that the test year was going to be $5,000 higher than the base period. I wanted to know how it got that $5,000 number. I wanted to know, how many employees there were, what were the specific employee salaries, what assumptions did they make in order to get from point A to point B. That's what's important to me as a revenue requirement witness. And to be honest, it's more difficult to do that, not only with the future test year, but it's more difficult to do that when you're faced with literally thousands of pages of exhibits that may not be that helpful to you, because you have to spend, the first couple of weeks trying to plow through the case, figuring out what it is that you're looking at. Even though SPS in this case, and frankly, the other utilities have all been as helpful as they can be with regard to assisting consultants and expert witnesses in trying to grasp those models. But it is a very difficult process. And in my view, you can spend quite a bit of time on things that ultimately, you really don't need to know. And that was my frustration with SPS. I just think that their cases in general, and I've had this complaint for several years, several cases. There have been some changes that have improved things relative to where they were a couple of cases ago. But I still think that their filings are much too complex. And I understand that there's a great fear that there will be, the commission will find, or the hearing examiner will find that there's a deficiency in their filing, which will then cause them to dismiss the filing. And I think they're trying to probably to overcompensate for that fear. So that's really what I was getting at in that section of my testimony.
Okay. And just generally, define for the record the difference between the information that's included in a historical test year and a future test year.
Okay. And, there's a little bit of a gray area. A historic test year, however, the base period essentially is a historic period of time. So you have actual numbers that you're working with. The future test year, at least in this case, not all cases, but in this case, is a totally forecasted period of time. So you have no real numbers. You can have a future test year that has that kind of has half actuals and half forecasts. So there are lots of different permutations between those two extremes. When you use a historic test year, you generally do not use those numbers unadjusted. So, but at least you have a base on which to begin your analysis. And then, depending on the regulatory jurisdiction, there are generally provisions made for known and measurable changes to that historic period. And each jurisdiction has a slightly different view of what constitutes a known and measurable change. So, as I said, each jurisdiction is a little bit different, but at least you have a foundation that's historic, and there's a greater limitation to the types of adjustments that you can make to that base period or that historic test year than you find in a future test year case.
In the future. And the past two cases, as a result, partially, that SPS filed, again, as a result of Hale and Sagamore wind facilities, the last two were historic, correct?
I believe that's correct, with some adjustments, permitted to that historic period.
Yes. But with a future test year, there's some kind of base period, and then there's the future test year. And then, so those are projection numbers, correct?
Yes, correct.
So we have some actual numbers, we have some projected numbers, and then the applicant is required to provide what's referred to as linkage data that somehow bridges between the actual and the projected, correct?
Correct.
And generally based upon your knowledge and experience, can you say which type or even other type of rate cases that you're seeing among the different jurisdictions that you testify in?
I don't quite understand your question. I mean, are you
Okay.
asking if some use future and some use historic, or?
Right. Well, yeah. Is there based upon your knowledge and experience, I know that we've talked about this in the past, all the different jurisdictions that you've testified in. And I just wondered if you know whether or not most of the jurisdictions are using future test years now. Are they using something different, or are they still relying on historic test years?
Well, in my experience, I don't know, the majority is I've testified in probably 18 or 19 states, but there's still a lot out there I haven't testified in. So I'm not sure what constitutes the majority. I will tell you from my experience, most jurisdictions that do use a historic test year do allow adjustments to that historic test year. Now, it varies. In some states, there's actually a specific period identified so that a company is permitted to reflect adjustments, let's call it 3, 6, or 9 months after the end of that historic test year, depending on the type of adjustment. It can be that formulistic. In other cases that I'm involved in, there are what I would call updates to that historic test year permitted through the litigation phase of the case, but that time period is cut off prior to the filing of testimony by the interveners, so that we do have updated information relative to the filing, but it's all actual information by the time that we actually get to, to file our testimony. To make it even more complicated, that's not to say, though, that then that's where the analysis stops. For example, even with the use of an updated test year, let's say I had to file testimony based exclusively on historic data, regulatory commissions will still frequently allow an additional, what they call pro forma adjustment to that data, if they feel that there is that is a known and measurable change. And the definition of known and measurable change can vary among parties. For example, though, let's say you had a labor contract that was going to be enforced for the next couple of years that had very specific increases. Generally, a regulatory commission would permit that kind of adjustment. But however, at the extreme, in some of these future test year cases, you're actually using really nothing more than a budget, that in order to craft your future test year. And so, in my view, budget information does not meet that known and measurable test for use in rate setting. So. Mm-hmm. There just isn't one answer to your question. There's a broad spectrum of the different types of rate making methodologies that are used. More and more companies are pushing for the use of a future test year because obviously it generally results in higher revenues for them. And they talk a lot about regulatory lag, and they also talk about the future test year, in many cases, reducing the frequency of rate cases, although I'm not sure I've actually seen that happen.
And that's sort of what I'm getting to, is I believe that, that I heard testimony earlier in the week, and hear a lot of testimony earlier in the week about credit rating agencies and regulatory lag and And I thought I heard something to the effect of, and I don't remember specifically, but I know that the concept of a future test year, I mean, they're getting their money sooner. And I thought I heard testimony that said that was a trend to request. I seem to get the feeling that there is testimony that historic test years are antiquated and that most companies want a future test year to get their money sooner. And I just wondered if that's what you're seeing.
Well, I think all companies want a future test year. I don't necessarily agree that the historic test year is completely antiquated, but I would agree that the companies want a future test year because it's certainly in their best interest to do so. Just as you'll see companies expanding the use of regulatory assets, you'll see them expanding the use of clause mechanisms in order to get more and more of their revenue through riders as opposed to through base rate. So there are a number of different avenues the companies are pursuing, in my view, in order to increase revenues and shift risk.
And is that also, that's not unique to New Mexico, that you have a fuel clause and a renewable rider and an energy efficiency rider, and potentially an electric vehicle transportation rider. And as you say, the increased use of regulatory assets, correct?
Yes, that's not unique to New Mexico.
Okay. I wanted to specifically hone in on to your testimony on pages 16 and 17, where you're talking about our other case, the one that hasn't been resolved, the grid mod case, and you made a recommendation that the revenue requirement be adjusted for the I think $4.3 million in your testimony on those pages.
Yes.
Do you believe that the stipulation encompasses that adjustment?
Yes, I do.
Okay. I also wanted to look at page 27 of your testimony.
Yes.
With regard to liquidated damages.
Yes.
And my understanding of that particular issue is, according to your testimony, page 27, the question posed at line 2, did SPS make any adjustments related to liquidated damages in the filing? You say yes, during the base period, SPS received approximately $12.5 million in liquidated damages from Vestas relating to the performance at the Hale and Sagamore wind farms. Vestas is the
vendor of
maker of the turbines. Don't they also manage at this point, the functions of the turbines? If you know
that, I don't know.
Okay, so it was whoever they had the contract with to provide the wind turbines, paid them $12.5 million relating to an availability covenant in the O&M service agreement between Vestas and SPS. SPS must pay SPS damages. Vestas must pay SPS damages in the event that the measured average availability of the facilities is less than the projected average availability. That's your testimony?
Yes.
And you go on, and basically they wanted to keep that 12.5, correct?
Yes.
And you're recommending no, they shouldn't be able to keep it, correct?
Yes.
And you go on and you talk about the Hale and Sagamore availability factors that were established in the CCN case, the 17-00044, and that there are certain financial consequences if the net capacity factor is not met, correct?
Yes.
Does that requirement, is that related to this measured average availability, or is that some other metric?
It's I would say it's probably related, but it's not the same metric. There's a specific calculation in the contract with Vestas that will determine whether or not Vestas owes penalties to the company for what they call this measured average availability of versus what they project. That's not quite the same calculation as the capacity factor calculation that the parties agreed to in the 17-00044 docket. And the capacity guarantee that was in that 17-00044 docket has in fact been met. So there were no penalties that resulted from that net capacity factor not being met. The Vestas penalty is a separate issue. Although obviously, all the issues about how the units are operated, I would think would have some impact on one another, but it's basically a separate calculation.
Can you explain for the record exactly what the agreement was regarding the minimum production in the CCN case of the?
I'm going to try.
Okay, of the net capacity factor of 48%. Generally?
Yes. Generally speaking, the agreement assumed a net capacity factor of 48%. And I believe there's a band around that. I can't remember exactly what that band is, but let's assume that it's a 2% band. So if the capacity factor falls below 46%, there's some sort of an additional payment or benefit that would accrue to ratepayers. And alternatively, if the unit is run at, let's say, above 50% capacity, there's some sort of a benefit that would accrue to the company. And there is sort of an annual commitment with regard to that capacity factor. And I think the way it works, although it's been a number of years since I looked at that agreement, is I think that there would be an adjustment that would be basically made ratepayers whole for any shortfall or rewarded customers or rewarded shareholders for any overages. And I think that actually probably flows through the fuel clause.
Okay, and you indicate further in your testimony on page 28 that that a net benefit analysis will be conducted for Hale and Sagamore after 10 years of operation, correct?
Yeah. There's really, I think, two different analyses that
okay
are per the agreement. One's on an annual basis, and then after 10 years, there's supposed to be sort of a macro analysis that will look at the entire operation over that 10-year period. And at that point, if it's determined that there was not a net benefit to ratepayers, then there are financial penalties to SPS.
Okay, but by saying on line well, I don't see it. But you just said the 48% was met.
The 48% was met, yes.
Okay.
I think I do have that somewhere in my testimony. Because the SPS argued in its rebuttal case that because of that 48% commitment and having met that commitment, that ratepayers were not entitled to any of the liquidated damages. And I disagreed with that. I said that if the company had to make a payment to ratepayers, then the liquidated damages should be reduced to reflect that payment that was made. However, in this particular case, no payment was required, and therefore the entire 12.5 million, which I believe is a total company basis, not a jurisdictional basis, just to clarify the amount of that liquidated damage, accrued to the benefit of shareholders. And that's what I took issue with.
Well, did you think it should be shared, or do you think it should all have gone to the ratepayers?
I think since ratepayers are basically paying for the overall cost of the facility, that it should have gone to ratepayers.
Okay. And that particular claim, that also got subsumed in the stipulation?
No, that is not addressed in the stipulation. When you asked me about the grid modernization costs, the grid modernization costs are specifically addressed in the stipulation as having been removed from this case. However, the liquidated damages adjustment is not mentioned in the stipulation. Now, there is a black box in the stipulation, and so parties can make any assumption they want with regard to what's included in that black box.
Right, and that's why I was saying it, that this particular issue got subsumed in whatever negotiations. But
correct.
But you accurately refer to that black box adjustment that's in the stipulation. And that would be section 12. Are you referring to, this is the signatory exhibit 1, and in section 1-12, it says, in consideration of the various revenue requirement adjustments proposed by the signatories,
I'm sorry, Judge, you're reading too fast. In section 1-12, it says,
in consideration of the various revenue requirement adjustments proposed by the signatories, but without specifically accepting or rejecting any such adjustment for the purposes of settlement, the signatories have agreed to an unspecified adjustment in the amount of $8,675,546, which, in conjunction with the stated cost of service components above, results in the stipulated increase in base revenue rates. Is that the black box adjustment that you're referring to, Ms. Crane?
Yes.
Okay. And then, I'll just note that you have other adjustments in your testimony that you believe should have been made to the case. One of the questions that I guess I would note, page 39 of your testimony.
Yes.
Too many black notebooks, Miss Crane. I need to I don't know, color them with something. I was picking up the stipulation notebook. So I'm looking at section 39, the Knox adjustment begins on page 38. And and my question to you is, in addition to I think a recommended course of action, I'm interested in the part at the bottom of page 39. Are you recommending any adjustment to the company's claim? And you're basically saying you're not opposed to removing the $110,000 cap that was established in 2010 in case number 10-00395 UT, that you believe circumstances have changed since that time and the commission may now find it appropriate to remove the cap. And you're also not opposed to recovering future NOx costs through the FPPCAC, assuming that the commission finds the recovery of the costs is permitted by law. And I'm like to ask why you think it's appropriate that the cost should go through the FPPCAC.
Well, I mean, these are costs that are directly related to the quantity of energy that's generated. And so I think there is a direct link there between the costs that typically would go through the fuel clause and these specific costs. So I'm not opposed. I mean, obviously, I would like to see base rates and no riders. I mean, that to me, that's the best type of rate making that you can have, and it provides the best incentive to the utility and the best protection to ratepayers. However, I'm also somewhat of a realist, and I know that I know that we have to deal with the cards that we have in our hand today, and certainly the fuel clause is one of those, and it's probably not going away. And so that's why I've accepted that treatment in this particular case.
Do you know whether or not any other types of regulatory costs get passed through the FPPCAC? Regulatory compliance costs?
I don't. I do recall many years ago, and I mean many, like maybe 15 years ago, there was an attempt to recover certain costs through the fuel clause, and it was found to be prohibited by statute, which is why I actually put that caveat in my testimony. I have no idea whether the statute has been revised since that time, nor do I know exactly what types of costs. I wasn't really a prohibition. It was more a positive identification of the types of costs that could be recovered through a fuel clause. And to the extent that a party attempted to recover a certain cost that was not permissible per statute, that request was denied. But in terms of what else may be recovered through the fuel clause at this time, I don't know.
Okay. One of the questions that I had that I think it related to your testimony beginning on page 55, that have to do, you're talking about the deferrals that SPS is requesting as set forth in Ms. Trammell's testimony, pages 115 and 116. And with regard to that particular testimony, and I believe it was in Ms. Trammell's rebuttal, she seems to be at that point suggesting that there would be some kind of true up that would ameliorate any potential discrepancies in the forecasted capital and actual numbers. Are you familiar with that?
It's ringing a bell.
Because I asked whether or not that was still going to be in place, and I believe that I asked SPS witness, and I was told no.
Right. It's my understanding that that won't be in place, and nor, in my view, should it necessarily be in place. And you're talking about plant here. You're talking specifically about plant here, because I think you mentioned page 55. I just want to make sure we're talking about the same thing, which is like regular.
And I can't, I can't find my note. My last page number note about what I wanted to ask about was page 54. So that's why I was trying to figure out where in your testimony, and maybe you didn't, maybe I'm just asking you to comment on Ms. Trammell's rebuttal. Let me pull it up.
I think I generally recall the gist of it, and it's that there could be a process established in order to true up actual plant balances that are in place during the test year. And that's, in my view, that then we're sort of into reimbursement rate making, right? I mean, there's two ways of looking at this. One, we could just kind of let the company file all of its costs once a year. We could look at those costs and we could write them a check, or they could write us a check, right? I mean, that's kind of the one extreme. In my view, regulation is supposed to be a substitute for competition. So I think it's preferable to set rates that are based on reasonable expectations. And then for the most part, and there are certain exceptions, but for the most part, then you just let things play out, right? And either, the company does a little bit better than anticipated, ratepayers do a little bit better than anticipated. And if things go south, the company always has the ability to come in and seek another rate case. So to me, that provides a much better incentive for the company than sitting there and at the end of the year just kind of writing them a check, which you can do. And if you're going to have a future test year, and some states do this, I mean, some states allow projected plant to be included in rates. And then sometime after that period ends, there is a true up mechanism. And sometimes it's done in base rates. Sometimes there are rider mechanisms for certain infrastructure projects where companies are able to recover certain costs between base rate cases that are also subject to true up. So there's all different ways that you can structure this. But I'm not a big fan of simply truing everything up at some point. I mean, going back to the issue of regulatory assets, basically, that's exactly what you're doing with the regulatory asset. You're truing things up, right? And I think that sends the wrong signals to the company. So I'm not upset that there's no true up mechanism included in the stipulation.
Okay. I just wanted your opinion because it I mean, it seems like to me it would be providing some accountability, and to be able to do that. But I understand what your testimony is here today. So do you believe that having all these regulatory asset requests discourages, is sort of a disincentive for prudent management?
I do, and I'm happy to say that most, if not all, of the ones listed on these pages were eliminated by the stipulation.
Okay, and then I also had a note that I think in Mr. Moeller's rebuttal, he had a criticism about your adjustment and regarding accelerated depreciation. Did you make an adjustment for accelerated depreciation?
I made a depreciation rate adjustment, but I'm not sure. I didn't make a specific adjustment for accelerated depreciation, so I'm not sure.
Okay, let me ask my question and see if this rings a bell. This comes from page 15 of Mr. Moeller's SPS witness Moeller's rebuttal. Did you adjust? Did your adjustment include 6 months of accelerated depreciation for 2023?
That I think maybe what he's referring to was the plant and service adjustment, the impact of the plant and service adjustment that I made. But I'm really not sure. Can you put that up?
I can. I just found Ms. Trammell, so let's see. Find Mr. Moeller. There he is. Let's see. 12. I have to make a note to myself to make sure that I put the page number. All right, so I think this is it. Proposed increases for depreciation expense for distribution and electric general function. And in the footnote, he says,
I think I know. I think I know maybe what he's referring to.
Okay, see that footnote?
Well, I don't actually see it because I don't think you're sharing your screen yet, but I think I know now.
Sorry.
That's okay.
I had share screen, I just didn't share it. There we go. See that footnote? Footnote 12?
Yes, he says where he says that, well, am I looking at 12 or 13? I'm looking at footnote 13. Is that?
Yep, there it is.
Okay.
Page 13.
Madam Hearing Examiner, we're seeing page 14. I think you were intending that, but I want you to understand. There's 13 for us now. Page 13.
Yeah, no, I thought it was on page 12, but I think it's actually on 14. He's responding.
Okay, here we are.
Proposes the commission reject the proposed increases in depreciation expense for, and then he cites to page 13, and then that's the footnote.
Well, the footnote 13 on page 12 simply talks about the fact that I did not oppose their new depreciation rates for
Right.
production and transmission. So all I said was that with regard to distribution and general plant, the current depreciation rates should be maintained. Now, it's the other sentence that you referred to there in his rebuttal testimony, seems to talk about the intergenerational equity issue.
Equity, right.
But I mean, that's always an issue with depreciation expense. I mean, there's always an attempt to have the ratepayers that benefit from the investment pay for that investment. However, at times there are other factors that need to be considered, like the overall impact on rates, like other legislation that might impact the retirement date of plant investment, or other factors. But so I'm not sure that we're in disagreement about about that.
Okay.
And I would add that there was some testimony. I think you had some testimony. It might have even been earlier today on what's included with regard to depreciation in the stipulation, and where he indicated in that footnote that I didn't take issue with the new rates for production plant or transmission plant, and it's actually my understanding that the depreciation rates that are included in the stipulation ultimately are those rates that would result from the Attorney General's recommendation in my testimony.
Mm-hmm. So you're referring to section 5. Depreciation rates is
Yes.
stated in Exhibit C.
Yeah.
Depreciation expense component. Yeah. Okay.
Those
I'm
rates
sorry, Judge. Depreciation rates is stated in Exhibit C.
And Miss Crane is saying yes.
Correct.
Okay. So just generally in looking at your stipulation testimony, Miss Crane, and yet again, you get picked to answer for all 3 witnesses regarding the testimony in support of the stipulation. What do you come away with as big wins for the positions that were advocated for the New Mexico Attorney General? Because when you look at this, I mean, yeah, they didn't get the 75 million revenue increase in the stipulation that they requested, but they sure got more than the 8 point something.
Mm-hmm.
The 8.6 that the Attorney General wanted, and agreeing on a 9.5 ROE is higher than the 9 point that was recommended.
Mm-hmm.
So what makes you feel good about the stipulation as far as the New Mexico Attorney General position?
Well, several things. And, I know there's been a lot of talk about cost of capital, for example, and with all due respect to the wonderful cost of capital witnesses for all parties in this case, to me, the bottom line is what amount our customers going to have to pay, right? And to be honest, when you look at Wall Street, I mean, what Wall Street is really interested in is earnings per share of the utility company, right? I mean, Wall Street analysts focus on earnings. What generates earnings? Revenues generate earnings. So my point is that given, let's call it a $33 million revenue increase, the earnings of the company are going to be what they're going to be, regardless of whether somebody states that it's a 9.5% ROE or a 9% ROE or a 10% ROE. they're going to get $33 million, and they're going to be able to do something with that $33 million. And however much they're able to squeeze out of that is going to accrue to their bottom line, period. So I just hope that we keep that in mind. Now, focusing on the 33 million, that's 43% of what they asked for. So I also would just remind the commission that in the last two cases, the stipulations, I believe, included a 54% or a little bit higher, slightly higher, 54% and change equity ratio. So although we agree to the higher equity ratio than what was recommended by Dr. Woolridge, there is some history for that. Obviously, cost of equity was the single biggest dollar issue in the case. However, we managed to eliminate 57% of the company's revenue increase. So I don't think that that's a bad number. More importantly, we also, or just as importantly, got rid of the potential to be burdened with many additional costs in the future by eliminating a lot of those regulatory assets that we've talked about. So we got some sort of rate surety with regard to that $33 million. In addition, the $33 million, because we did eliminate the one toll regulatory asset, we did agree to give the company, I think it's about $980,000 more in revenue that was not reflected in my recommendation. So, you also have to factor that in. Also, the stipulation will return the Lubbock payments to ratepayers over a much quicker period of time than was proposed by SPS in its filing. So I think we have to sort of allocate mentally some dollars for that provision. And you end up with a customer charge for residential customers that I think is only 20 cents higher than what Dr. Gigax had recommended in his testimony. So when you put all of that together, I think on balance, you reach the conclusion that the stipulation is reasonable. Would I have liked to have done better? Sure. But, hopefully SPS would have liked to have done better as well. But on balance, I think that this is a reasonable compromise. And, I would remind you that all parties are also dealing with a somewhat unknown commission here. We all had litigation risk. And I think, frankly, in this case, the litigation risk is enhanced because we do have, a new commission, not only new commissioners, but also a whole new format for the commission. And so there's a lot of uncertainty there for all parties. And frankly, I think we all took that into account as well when we were deciding whether or not, to support this stipulation.
Okay. And I just indicate for the record that that you summarize the majority of the things that you're referencing in your testimony, pages 6 through 9, including the depreciation change that you felt like was a win that you testified to earlier. Also on page 7, you talked about the reduction of rate case expenses and amortization period, as well as the stipulation adopting the cash working capital and elimination of the grid mod, as well as the elimination of the 2022 and 2023 NOx allowance costs. So my comment to myself after reading your testimony is, looks like you did pretty well.
Well, I hope so. I hope so. I mean, I think I did well enough to recommend that the AG sign the stipulation. So I guess we'll see where it goes.
All right. as well as on page 8, line 17 through 19, the stipulation, the claim is that the stipulation eliminates a substantial amount of risk to ratepayers associated with the regulatory assets and trackers, which I think that you've talked about earlier today.
Regulatory assets and
trackers. Sorry, Mr. Lee. I think I had a bench request for you, Ms. Crane.
Yes, I believe that
you answered. Is that correct?
I sent the material to the Office of Attorney General. I'm not sure.
Yeah,
what happened after
it got
that.
filed. I'm just trying to find it. I am finding, looks like all of them except. I believe I labeled it Commission. Exhibit 2. Well, scrolling through the Dropbox, I don't know why it's not listed in alphabetical order. Anyway, the answers that you provided in the bench request, Ms. Crane, true and accurate?
It was. It was basically just to forward a data request response to you.
Okay. And it was complete?
It was.
And you produced it?
Well, actually, I did not produce it. It was a data request response from SPS that you had asked me for support for, I believe, the update on plant and service. I think that's what we're talking about. And when I prepared my testimony, just as I was ready to submit my testimony, they provided an update for 1 more month. I did not have time to incorporate that update in my testimony. However, I was able to take a quick look at it, and I believe I have a footnote in my testimony where I state that I received that response and that if I had incorporated it, it would have made my my recommendation a little bit lower, or that it supported my recommendation, something to that, words to that effect.
Okay.
You asked me, I believe, to furnish that update to you, which is what I did, but it was prepared by SPS.
Okay, I know, I'm just saying the document that was included as the part of the bench response was the entire document that you were referencing in the response.
Yes.
Okay, very well. I believe this is Commission Exhibit number 2 in its SPS's response. SPS's. It's the New Mexico Attorney General's response to bench request. Is there any objection to admitting Commission Exhibit 2 into the record? Hearing none, Commission Exhibit 2 as provided by Ms. Crane and the Attorney General will be admitted. Ms. Crane, I thank you. Appreciate your information as usual, your testimony, and I don't have any further questions, but I believe Commissioner Aguilar, sir, do you have questions for Ms. Crane?
Yes, Madam.
Go ahead, sir.
I do. Okay, so hi, Ms. Crane. Good afternoon at this point.
Good afternoon.
Thank you for appearing and for your testimony. I have several of the same questions that the hearing examiner already asked. So hopefully I can avoid asking you the same question twice. I'm gonna have to maybe modify them a little bit on the spot. But Ms. Crane, so the stipulation includes a rate case expense of 2 million amortized over 2 years. And SPS's initial request included a cost for this rate case of about 2.7 million, a little bit less than that. In your initial testimony on page 42, you explained that there must be some assurance that the rate case costs passed through to ratepayers are reasonable and appropriate. I agree. And you go on to recommend a rate case cost of 1.7 million with a 3-year amortization. So I want to ask, do you believe that the rate case cost being requested in the stipulation is reasonable, and why or why not?
Sure. Well, first of all, I recommended 1.7. The stipulation includes $2 million. So it is somewhat higher, a little bit higher than what I recommended, but I would say it's in my ballpark. However, more importantly, those funds will be amortized over a 2-year period. To the extent that there are funds that are not recovered when the company comes back in, they lose the ability through the stipulation to come back and seek those additional funds in the future. So I know at this point that the ratepayers' absolute liability is capped at $2 million. Now, let's assume that the company only spends $1.5 million. All right. Frankly, that other $500,000 over 2 years is going to accrue to the benefit of shareholders. However, again, I felt that given the fact that in the last 3 cases, there were actual costs of about 1.7, the $2 million figure was not that out of line with what actual costs have been. Having said that, I don't necessarily know with surety that all of those costs that were incurred in the last 3 rate cases were reasonable either. It's just at some point we're limited as to how much time we can spend plowing through invoices, et cetera. But I had to make the assumption that the last 3 cases did result in reasonable costs, and that we're sort of in that ballpark. And if the ratepayers, the revenue requirement is not going to change. The 33 million doesn't change, regardless of how much of that gets attributable to rate case costs.
Great, thank you for that. And since the use of a future test year is expected to reduce SPS's base rate case filings, are you supportive of the 2-year amortization instead of the 3-year that you initially suggested?
Well, again, I'm supportive of the 2-year amortization because it really doesn't matter now. As long as they're prohibited from coming back and recouping anything that is unamortized, it's sort of immaterial whether they use a 1-year, a 2-year, a 3-year, a 5-year, a 10-year. It doesn't really matter from the ratepayer's perspective. Now, it will matter from their auditor's perspective. And that's basically the reason that we identify what the amortization period is, because on their books and records, they will take that $2 million and they will amortize it over a 2-year period, for financial reporting purposes. So it's important to them. It's kind of not that important to ratepayers because it's no longer going to have any impact on future rates. The 33 million is what it is, and going forward, we'll never see any unamortized balance associated with this particular rate case again. So I guess I was willing to accept the amortization period, but it's not really going to impact ratepayers if we went with some other amortization period, given the fact that they can't come back and recoup any unamortized amounts.
Okay, thank you for that response and clarification. So I'll move on to a different question. In your initial testimony, you discussed certain incentive compensation expense adjustments And among those is the LTIP, which stands for Long-Term Incentive Plan.
Correct.
You explained that SPS is seeking recovery of those portions of the LTIP that are based on environmental stewardship, and you recommend that those costs associated with environmental stewardship be disallowed. Can you explain how these same costs would be reflected under this stipulation?
Sure. The company certainly, the company is going to get, if the stipulation is approved, the company is going to be able to increase its rates by $33 million, right? They will be able to award, whatever degree of compensation is authorized by, presumably by the Board of Directors Compensation Committee, to its employees and its executives. So the stipulation doesn't mandate how much compensation is actually paid to any of those individuals. The stipulation is silent with regard to whether or not those environmental stewardship costs are actually being collected from ratepayers. And again, that's one of the items that potentially is in that black box. I mean, people can kind of assume that it's in, or they can assume that it's out, and something else is in that black box.
Right.
So it's this, but the stipulation is silent on that issue.
Yeah. Yeah, I thank you for that response. I understand that. I mean, I thought you had persuasive arguments in your initial testimony, that, there is the ETA and it's a law. Not sure why SPS would need to be SPS's shareholders would need to be incentivized to comply with the law. But thank you for that response. So I guess I have a more general question. I mean, I understand the rate does not, the stipulation does not include any kind of rate moratorium. And just wanted to ask, because you have a lot of experience with rate cases, if you can tell me from your experience when rate moratoriums are considered and appropriate.
Well, in my experience, they're always appropriate, but they may or may not be considered. Generally in negotiations, parties will attempt to get a rate moratorium as part of any stipulation. And sometimes parties are successful in doing so. In some cases, they're not successful in doing so. I would love to always be able to include a rate moratorium in any settlement. But unfortunately, that's not the case, and there's not a rate moratorium included in the stipulation in this case.
Okay, thank you. Yeah, just something I'm trying to weigh, especially with some of these incentives, like the one we talked about with the rate case cost and being amortized over 2 years. Something like that just becomes more important. So the hearing examiner also asked about the liquidated damages, which I wanted to ask about as well. So you explained that the payments SPS received associated with the non-performance at Hale and Sagamore should not be retained by shareholders. I guess my question is, how are the payments reflected in the stipulation? Although I anticipate your response.
Yeah, they're not stated in the stipulation. So, one could suggest that they also are part of the black box, or one could argue that they're being retained by shareholders. It might be helpful though, just to, as I mentioned, the 12.5 million, which is a pretty big number, is a total company number. And if you take a look at my schedule ACC 8 from my direct testimony, I break it down there. I propose a 3-year amortization, first of all, of that $12 million, which is would result in about a $4 million a year adjustment, but then I allocate 39.2% of that amount to the New Mexico jurisdiction. So on an annual basis, we were talking about an adjustment of $1.6 million for 3 years, just so that you can put that in perspective, relative to the $12.5 million figure.
Can you tell me which schedule that was again, please?
Sure. It's Appendix B, which are my schedules, and then it's Schedule ACC 8.
Okay. We just. That's it?
Yes.
So, okay, so the 12.5 actually becomes 1.6.
Right. And the 1.6 is an annual number for 3 years. So if you wanted to look at the total impact to New Mexico, it would be 1.6 times 3. But on an annual revenue requirement basis, it's 1.6.
And that 12.5 was just for 1 year, right?
It was for one period. I believe it may have been a period that was a little bit longer than a year. It was for whatever claim. It was the amount that was claimed in that particular submission by the company. Now, since that, as I say in my testimony, since they received the $12.5 million, they've made another claim for something like it's in the $1 million range, maybe 1.2, something like that, for a later period of time. So I presume that it could potentially be maybe an annual type of adjustment. So there is a second payment, which is requested. I don't know that it's been approved or paid yet. That is considerably smaller than the $12.5 million.
Thank you. Commissioner?
Thank you. Okay, so I wanted to ask if you could elaborate on something that was mentioned before regarding benefits from received by ratepayers from Lubbock to the FPP-CAC. I think this is on page 10 of your testimony in support of the stipulation. Can you just elaborate on how those benefits result?
Yes, and they actually result in 2 ways. And I hope my recollection is correct, but in the company's original filing, they proposed that they would get these payments, they would amortize them over a period of 3 years, and that at some point in time, they would begin to flow those payments through to ratepayers. And again, I'm not sure exactly, which would have allowed them to retain a certain number of months of that amortization, they being shareholders. All right. So but basically ratepayers, I believe it was a 3-year period that they would have to wait to get all of their share of the payments. In the stipulation also talks about there being a 3-year amortization, but only to determine how much of those payments can be retained by shareholders. And I believe it's 236 can be retained by shareholders. The rest has to go to ratepayers, and it's being returned over a 1-year period rather than a 3-year period. So they're getting potentially more of that money, and they're getting it much faster than they would have under the company's proposal.
Okay, I understand that better now. Thank you. And my last question was going to be with respect to, the benefits, because you had stated in your testimony in support of the stipulation that if your original recommendation was adjusted to reflect the 54.7% equity ratio and 9.5 ROE, that the overall increase would be about 24.2 million. And then, you're settling at 33 million, but so I was going to ask, what is that additional benefit comprised of? But the hearing examiner already asked that, so I appreciate that response as well. So I think I have exhausted my questions. So thank you again for your responses and your testimonies.
Thank you, Commissioner.
Thank you, Commissioner. I also believe that the chair has questions for Ms. Crane. Sir, is your pleasure to go ahead now, or should I call for lunch?
I don't think I have very many questions, so I'm happy to plow ahead if Mr. Lee
All right,
can
sir.
tolerate it.
Mr. Lee, is it okay if we go a few more minutes?
Yes, ma'am.
All right, sir. Go ahead, sir.
Thank you, Ms. Crane. Your testimony always makes me think, so that's fantastic, especially in my new role. Nice to see you again.
Nice to see you.
I just had a couple questions. One is going to the stipulation, the paragraph 8, the NOx allowance costs. Yeah, I heard you talking about being a realist in terms of that provision. Just wondering if in your work, did you do any quantification of the impact that might have on residential customers in terms of dollars they're going to see in their bills?
Right. I did not. I did not. However, we do know that that the stipulation eliminates the 2022 and 2023 deferral that the company requested in its original filing. So that is a very easily quantifiable benefit to customers relative to their filing. And I should have that number on my summary schedule. That was about a $1.3 million benefit to ratepayers by eliminating the 2022 and 2023 costs. Now, going forward, though, I did not attempt to try and quantify what the costs might be going forward.
Yeah, thank you. And as I shared with Ms. Glick earlier this morning, my main concern here is just if we're adding another volatility element to the total customer bill. So I wonder if you have any concerns about volatility or just an observation on what volatility can do to residential customers.
Well, I always have concerns about volatility, which is why I generally take the position that I prefer to recover costs through base rates rather than through rider mechanisms or regulatory assets or other types of mechanisms. So I share those concerns with you, especially when you're looking at something as volatile as a fuel clause potentially. On the other hand, the company argues that it is that very volatility that makes the fuel clause necessary, because it would be too much risk for its shareholders if they were the ones who had to absorb that volatility. So I guess we disagree. I disagree with the company on who should share that risk, and ultimately we try and balance that risk by putting certain things in base rates and permitting the company to recover other costs through rider mechanisms like the fuel clause. And ultimately, it's the commission's decision as to how much of that risk, should be put on ratepayers through rider mechanisms versus put on the company through base rates. I will say, in the company's defense, they will argue that the rider is not necessarily a burden, because when costs go down, the ratepayers do benefit from that reduction, something that doesn't happen when there's a reduction of a cost that's being recovered through base rates. And they are right about that. Riders can go up and down, especially the fuel clause rider. In my experience, most other riders just go up, but fuel costs can in fact decrease, and then it is a benefit to ratepayers to have those costs in a rider.
Yeah, thank you. I appreciate those observations. And frankly, another thing we heard this week is that ROE allows the company to absorb risk. Hope I'm understanding what I heard there correctly, but so that's another reason for asking about the order of magnitude of volatility that we're talking about here with paragraph 8. Not just what does it do to customers, but is it the kind of thing that is small relative to other risks? So return, sorry, I'm losing the acronym right now, but ROE would absorb it. So are we just making the, ROE argument less compelling with this paragraph?
Right. Well, this is basically a change for how these costs were treated in the past. We can certainly look at, I would think that the parties and the commission could re-examine rate making treatment for these costs in the future if it was felt that it was no longer appropriate to recover them through the fuel clause.
Well, thank you for that. And then another element of just, I appreciate your expertise and experience. And so just, you've already talked about concern for volatility on bills for residential customers, and your testimony is loud and clear. The best thing we can do is lowest revenue requirement. But then, one of the things that got eliminated in this stipulation is the EAP. So your direct testimony on page 62, you state a preference for governments funding those type of programs for low income customers. So just wondering, your scope of work spans the whole country. Do you see any government programs that you would recommend for that type of assistance to customers?
Well, on the on usually like on the gas side, I mean, there are LIHEAP programs and other types of programs that provide assistance to low income customers. There are proposals out there to do what was proposed here and to basically have two different levels of rates for different income customers. I mean, to me, that's problematic for a number of different reasons. But those programs are certainly out there as well. I'm not really familiar with specific state assistance programs, but I presume they're out there. There are other types of things like, budget billing plans that utilities can establish. There's been some discussion of prepayment plans in some utilities that is presumably could help certain ratepayers to meet their obligations. There are ways that you can assist customers in making what I would call fee-free payments by, for example, customers that for whatever reason can't pay their bills online can usually go to a location and pay their bill in person at a location. And there are ways that we can look into mitigating costs associated with those types of payment options on ratepayers. So I know that's sort of a very general answer, but my area of expertise, there are consultants that do nothing but look at issues affecting low-income customers and payments associated with low-income customers. I'm generally looking at a broader body of ratepayers, so I'm less familiar with those details than some other people may be.
Yeah, I appreciate your attempt to dive into the details. Just trying to hear if there are state level programs that have impact similar to what got on the cutting room floor here with the stipulation. And I guess summary of what I heard was you don't have any specifics to point to. Is that fair?
Right, I don't.
Okay, so just one more extra credit question, again, relying on your expertise. Paragraph, I guess that's 2019 on page 9 of the stipulation, the rate design and tariff issues.
Yes.
When you see a company agreeing to collaborate with parties, what do you think that means?
I think it means that somebody didn't get quite what they wanted in a stipulation, but we're all trying to make one another feel a little bit better. So we're going to talk about future collaboration, to be blunt. I think I view it more as a placeholder than anything else. So I view this as SPS's agreement that they will in fact collaborate, because there are people that feel strongly about cost-based time of use fuel and base rates for SPS, and I presume there are various opinions about the pros and cons of those kinds of programs, and it's an issue that probably requires further discussion among the parties that we weren't really able to resolve here.
Yeah, I'm asking because we were recently confronted by a wide gap between what the company thought and what the people who signed the stipulation thought on a word like collaborate. So just curious to hear your expectation for what the company should do if it promised to collaborate with you, for example.
Well, I would hope they'd start by reaching out to me and saying, do you want to schedule a meeting and get together and discuss the issues? Now, where it went from there, I guess, would remain to be seen. But it is a fairly general provision as currently worded in this stipulation, with regard to timing or scope. The other thing I'll say is that in negotiating a stipulation, sometimes too, you just run out of time. If the parties had another month to negotiate the stipulation, there may have been more specificity with regard to some of these provisions than you're seeing now. And at the end of the day, we all just kind of had to do the best that we could based on the time that we had in order to come to some agreement, given the procedural schedule in the case.
All right, and then I take it from the response that whether the Attorney General is an interested party, maybe you aren't directly an interested party in this provision.
I'm sure that Dr. Gigax would be an interested party on behalf of the Attorney General, but it would be Dr. Gigax.
Okay, thank you for that. And no, again, thank you for your testimony, and no further questions from me.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Commissioner Ellison, any questions from you, sir?
I do have some questions. However, I do not want to be accused of standing in between people and their lunch. So I'm
okay.
just wondering what's the best timing here.
Well, if you have more than a few minutes, would it be okay if we came back and heard those questions at 1:30?
Yes, absolutely.
Okay, unless there's some objection, then Ms. Creed, have an enjoyable lunch, everyone. We will recess until 1:30, and then we'll come back, and the commissioner will have some questions for Ms. Crane. Thank you all. Remember, the YouTube stays on, so mute and or whatever accordingly. Thank you.
Thank you.
Judge,
Mr. Lee,
I'm having an issue with my computer. I need 2 more minutes if I can.
tell me again, sir.
I'm having an issue with my computer. I need 2 more minutes if I can.
Oh, take as much time. Let me know when you're ready, sir.
You bet.
Okay.
Okay, Judge, I'm ready.
All right, sir. Very well, then we are back on from our luncheon recess. And I believe Commissioner Ellison, you have some questions for Ms. Crane.
I do.
Go ahead, sir.
Hi, Ms. Crane. Good afternoon.
Good afternoon.
Thank you for your testimony and for appearing here today. The stipulation, is it based on a future test year?
Yes.
You had mentioned that frequently future test years can involve speculation. In your view, is this future test year grounded in reality?
Well, I guess I'd say it's grounded in reality to the extent that any future test year can be grounded in reality. I mean, almost by definition, with a future test year, there are going to be assumptions and unknowns, and they're not going to be known until after the end of the future test year. So regardless of what stipulation we came up with, or frankly, what decision the commission were to come up with, it would still be based to some extent on projections for calendar year 2024. But the company has, a legislative right to file a future test year. So I don't know that there's a lot that we can do about that, except just do the best job we can when we're analyzing the underlying details.
But in general, would you characterize this future test year proposal as, being similar to what a historic test year might be, or deviating quite a bit in terms of, I guess, the uncertainty?
Well, I mean, if you're going to compare to a historic test year, it deviates quite a bit, because the test year period of January 1, 2024, the beginning of that test year is a full 18 months after the end of the base period. So now some of that is now actual, but we have a long way to go yet still in 2023. And then, of course, all of 2024 is projected. So it's quite a bit different than a historic test year. I will say that if we're just comparing one company's future test year filing with another company's future test year filing, I would say that in this case, I believe that we have vetted the adjustments to the future test year, as well as we could have. I think that we've gotten rid of some of the more troubling aspects of the company's filing, and I'm comfortable with where we ended up. But, by definition, if you're using a fully forecasted test year, there's going to be unknowns and uncertainty.
You said that the company has the right to file a future test year case. In a fully litigated case. Could the commission insist on using a historical year?
I don't know the answer to that. I'm not sure whether it's the legislation permits the company to file a future test year, or whether it requires the commission to accept a future test year that meets the criteria as defined in the statute. So I'm not sure whether the commission is bound to accept the use of a future test year, or whether it can reject that.
Okay. In your testimony, one thing you talk about is the uncollectible allowance rate of 0.55%. I forget exactly on what page that is, but I do recall seeing that in your testimony. Oh, page 37, I'm seeing here now. And so in the stipulation, has this number been adopted, or is that another one of these black box items?
Well, the stipulation doesn't, we don't have to define what that number is in the stipulation. And I don't think and the stipulation certainly doesn't define that number. I'm not sure that any party, though, raised an issue with regard to that particular rate. And I didn't raise an issue either with regard to the rate of uncollectibles. What my adjustment did was, if I was recommending a lower overall revenue number, then the 0.55% of my revenue is a lower number than 0.55% of the company's number. So whatever uncollectible rate you think is appropriate then should be matched with the level of revenues that you recommend in order to calculate the uncollectible expense that you think is going to be incurred during that period. And that's what I did when I filed my testimony. And I think the assumption would be that the revenue reflects that rate, because I don't recall any party disputing that rate. But there's no true up or anything of that rate. When the company files its next base rate case, it will file an updated uncollectible rate based on whatever their experience is at that point in time.
So that 0.55% is a percent of the total revenue. So you could think about it as a percent of total power sold, or total revenue from all power sold. Did the company provide any data to support that rate?
They did, and I can't recall exactly what I know. I examined their calculation and was comfortable with it. I can't recall whether or not they made an explicit adjustment or not for COVID. I mean, ordinarily, what you do is you go back and you look like either 3 or 5 years at what uncollectible rates have been. And generally, we would use a 3 or a 5 year average as a good proxy for the future. Now, COVID has upset that apple cart, if you will, because things were not normal during that period of, let's say, 2020 and into 2021. And I'm just not recalling exactly how they calculated their number, but we did go back and look at historic information, and we looked at what the company did, and we were comfortable with that ratio.
Did you have enough information to assess what level of effort the company is making to collect debt? For example, do they frequently employ disconnections in order to collect on their debt?
I did not examine the specific, customer service aspects from an operational perspective of debt collection. So I don't know. I mean, it's my understanding that a lot of states have regulations that somewhat protect ratepayers in certain circumstances, or that require certain actions be taken prior to cutting somebody off. But I'm just not familiar with the specifics at SPS.
Right, I understand. I guess my concern here is that if we, give them all of the uncollected debt and they're not making much of an effort to collect, then there isn't much of an incentive to collect. So I guess that's, the thinking behind my questions on that. You also talk about appeals and make the point here that if the company is able to get recovery through rates for every appeal, that they have the incentive to file appeals to every single decision. And that seems to be the history based on what I know about what's been happening, that there's an appeal for every single decision. So what is the alternative in your view to the status quo on that?
Well, first of all, I'm not an attorney, and I know there's been a lot of discussion about legal rights to collect regulatory costs. The utilities claim certain rights with regard to regulatory costs. So I'm just saying, making that caveat, because I'm not speaking as an attorney when I answer your question. But in my view, one of the things that you should be able to do, at least from a rate making perspective, is have shareholders absorb the costs of the appeal. It's very frustrating to me when I see companies come in and appeal decisions, and then they turn right around and they charge the ratepayers, or attempt to charge the ratepayers for those appeals. So that's one way to protect ratepayers. I don't know that there's any way that you can prohibit a company from filing an appeal. I guess. Well, I seem to recall, hearing from an attorney that some states it's easier to file an appeal process than in other states. I don't know the details of that. So maybe there is some other mechanism that could be employed in New Mexico to make it somewhat more difficult to file an appeal, because it seems to be pretty easy in New Mexico. But I don't really know the details about that. But certainly ratepayers, in my view, should not be paying those costs. And we attempt to get those excluded, in every case. And we had some success here with regard to regulatory assets and requests for deferrals.
Right. And certainly the company has the right to appeal, but the commission does not have to decide that those are prudent costs that should be passed on to the ratepayer.
Correct. And can we go back to your uncollectible question? Because
sure.
I just wanted to mention when you started talking about the appeal costs, you talked about incentives. And actually, the company does have an incentive to keep that uncollectible rate low in a sense, because once that's set, like in this case, our rates, let's say, assume that it's an uncollectible rate of 0.55%. Well, if in the next year, the company can reduce that uncollectible rate to, let's call it 0.4%, then those additional revenues will actually accrue to the benefit of shareholders, at least until there's another base rate case. And so there is somewhat of an incentive for them to try and minimize those uncollectibles. And also, I will say that the uncollectible rate of 0.55% is within the range of reasonableness, of what we see. I mean, I would say that typically we see rates, maybe anywhere from 0.35, up to maybe 0.60 or something like that. I mean, there are some companies, unfortunately, that have collectible rates that, are in the 5 or 10% rate. I mean, they're just astronomical, but that's very rare. But the rates we're talking about here are within the range of reasonableness, which is another reason why I feel comfortable with that 0.55%.
Great, thank you. I appreciate that additional information. Another item you mentioned was the property tax. I guess the projected property tax in the future test year as being quite a bit higher than you'd expect. Did that get addressed in the stipulation, or is that an item that we can talk about?
Sure. Yeah, and this is a fairly common situation where you have companies that file a future test year. This is one area that we typically see very high claims for adjustments. And, and it's difficult. I mean, it's difficult to come in and to say what the property tax expenses are likely to be. You're dealing with a lot of different municipalities. You're dealing with different entities that may value the property differently. Some people or some locations may use market value, some might use book value, some might use a percentage of market value. And then of course you're dealing with tax rates that would be applied to that assessment. So it can be a very complex exercise. And lots of times you'll see utilities provide very complex calculations of how they got to their numbers. And in my view, what's more useful than spending an awful lot of time on those speculative calculations is just to kind of take a look at their claim relative to what the experience has been in the past with regard to annual increases, and make some assumptions about overall reasonableness. And, that's what I tried to do here. And I tried to tie the adjustment to the increase in their plant, because property tax is, based on plant ultimately, in order to gauge whether or not I thought, their claim was reasonable. And I decided it was not. We did not address that explicitly in the stipulation, but again, that's why we have that wonderful black box in there.
So that it was not explicitly expressed, or it's not information available to the commission at this point.
Correct. I mean, it won't be known until after 2024 sometime. We won't know what the actual property tax expense is until basically the end of the test year, the future test year.
Okay, but do we know what expense went into the future test year, or?
Yeah, the company did provide work papers, and it's my recollection they provided a lot of work papers with their assumptions about assessments, property assessments, how the property would actually be valued by different taxing entities, and then the rates that would likely be applied to that property. I looked at all of that, and it just it seemed excessive to me, which is why I recommended an adjustment.
But, sorry to belabor the point, but do we know what actually got into the stipulation then if it was adjusted?
There's nothing explicit in the stipulation. As I've indicated, there's a black box of about $8.5 million or $8 million plus dollars. And so that would certainly be enough to encompass a property tax adjustment that I recommend in my testimony. But it's not specified as to what additional adjustments go into that final number.
Okay, thank you. You mentioned in your testimony that you developed a financial model such that you could look at how changes in ROE, capital structure, depreciation, operating costs flow through to the revenue requirement. Is that correct?
Well, the company has a very detailed model that links various components of the revenue requirement. My schedules are more on a standalone issue by issue basis. So I'm looking at each individual adjustment that I'm recommending to their model, and then I'm quantifying that on a standalone basis for each adjustment. Now, I do link certain things in my schedules. For example, my first schedule always is a cost of capital schedule, and that schedule takes the company, regardless of which company it is, which utility I'm working with, takes that rate base, and it recalculates what the return would be based on my client's recommended capital structure and cost of capital. That's the first adjustment, and then that part is built into my schedule. So for any subsequent rate base adjustment that I were to make, any subsequent rate base adjustments would be priced out at, in this case, the AG's capital structure and cost of capital. Because if I made that first adjustment to cost of capital, and then I used the company's cost of capital for each subsequent adjustment, like let's say a plant adjustment or something like that, I'd be double counting the impact of that cost of capital adjustment. So the first thing I'm doing is I'm bringing everything down. What would the company's case look like using our cost of capital and capital structure, and then each adjustment under that assumes the New Mexico Attorney General's cost of capital in this particular case.
Right. So, and I did see where in your testimony about the stipulation, you did a true up to look at how different the stipulation is from what you had proposed if we were to use the stipulated ROE and capital structure. Is that correct?
Yes, I do just run that through. And there's actually two impacts, because that second adjustment on that list that was just up on the screen is interest synchronization. And that's related to the capital structure, because the more debt you have in your capital structure, the higher your interest expense is going to be. And since interest expense is tax deductible, the lower your taxes are going to be. And so it's not just changing the ROE, for example, but the change in the capital structure will also impact your interest expense calculation, which runs through your revenue requirement.
How difficult an exercise would it be for you if we were to request a calculation based on a 9% ROE? If, for example, everything, the capital structure and, everything else in the stipulation stayed in place, and we just wanted to see the how the revenue requirement might change from lowering the ROE to 9%.
That's very doable. If it's very easy for me to do, if you wanted me to do that based on my schedules. If you want that done based on the stipulation, actually the company, I think, has that model. I'm not sure I have the Excel file, but I'm sure between me and the company, we could do that very easily. I think if we went into that model, if I could get the Excel file from them, I could go in and do that calculation very easily.
Okay. I would like to see that, how the, using the assumptions of the stipulated agreement, how the revenue requirement would change if a 9% ROE were adopted.
And that's the only change to the stipulation.
Yes, just,
okay.
Just I'm just asking as a point of reference. I'd like to know how much the revenue requirement would change.
I think we can do that.
Great, thank you. That would be fantastic.
Okay, consider that a bench request. Mr. Getco, Ms. Hardy, that could be a collaborative bench request between SPS and the Attorney General if Ms. Crane doesn't have the information that she needs to make that calculation. All right. Go ahead, sir.
Great, thank you. And Ms. Crane, the model that this financial model that you've developed, is that available to the PRC?
I don't have a financial model per se in this case. In some cases I do. In this case I don't. I simply have the schedules that are attached to my testimony, which are more or less standalone type of schedules. So I'm actually going into the company's model, looking at a specific item, be it a rate-based item or an expense item, and then quantifying individual adjustments, sort of one schedule at a time, if you will. But my schedules, you certainly have, I can certainly provide the Excel files associated with my schedules to the commission, but they're still more or less on a standalone issue by issue basis, as opposed to the company's model, which basically can be tied right into their books and records of account. So they can just kind of go into their, accounting books and pull off whatever number they want, or all the numbers in there, and kind of incorporate that into one, massive model, which they can file, which is basically what they've done in this case. But I'm certainly happy to share to provide you what I can with regard to the Excel file that I use.
Okay, let me think about that. I just wanted to know what what's been provided and how that generally works. But I'll think about that. One question which I don't believe came up in your testimony, there has been discussion about the production tax credit for wind for the 2 wind farms and the possibility that the possibility of being able to sell those tax credits. Are you familiar with that issue?
Yeah, I didn't hear much of that discussion. So like in this case, I guess I missed some of that testimony, but I'm generally familiar with that issue. My recollection is a little foggy because that issue, I worked on that issue a lot when we actually had the Hale and Sagamore cases, and I worked on the stipulation that where the parties agreed to put Hale and Sagamore in. So I'm generally familiar with that PTC issue, and I can tell you how I think it works if you.
Well, yeah, I'm just wondering your view on, what's the proper regulatory treatment of that if, the company is able to sell the production tax credits, what's the treatment of those funds?
Well, it's my recollection, and we can all go back and look at that stipulation on Hale and Sagamore, but it's my recollection that ratepayers are getting credit for those production tax credits. I thought through the fuel clause, or if they're not, they will when we do this sort of 10-year look back, because that was a big issue in the last case. I mean, in the case where Hale and Sagamore actually where we agreed on that process for evaluating those wind farms, because everyone recognized that it was unlikely that SPS was going to be able to utilize those production tax credits because it just wasn't going to have enough income to offset that. Right. And in fact, one of the things that I believe, I'm pretty sure that ratepayers are getting some sort of a credit for those production tax credits as if they in fact were being used. Because I remember at one point SPS wanted to then build up a regulatory asset for the benefits that they passed through to ratepayers, but hadn't actually been able to utilize themselves. And that was a very sticky point in the negotiations in that case, because we did not want very large deferrals accruing that potentially could sit on their books and cost ratepayers hundreds of millions of dollars in the future. I mean, it got to be a very big number very quickly. And I think what we agreed to was that the company could build up some deferral over some limited period of time. There might have been a cap on what the total amount of the deferral that they could claim because basically their argument was, we're giving ratepayers this benefit, but we're not able to monetize it, or we're not able to utilize it ourselves because we don't have the revenue. And so the PTCs were addressed extensively, I believe, in that Hale and Sagamore agreement. And I think we are getting benefits regardless of whether or not they're actually monetized by the company. So to answer your question, we should get the benefits, period. And I think we probably are getting the benefits, but that is all subject to, my remembering a case from 3 or 4 years ago. And to be honest, once I'm finished with the case, I move on to the next one. I don't always retain complete details of the prior proceeding. So
sure. Well, what you've said is very helpful. Looks like I have a little bit of historical reading to do, but that's good to know that it was thoroughly addressed.
Yeah, it was.
Let's see. I did want to ask your view on if the commission were to reject the stipulation in your view, is there sufficient evidence to support, say, a 9% ROE determination?
Well, the stipulation obviously is a package deal, and there's been give and take to arrive at the document that's before you. On a standalone basis, if you were looking at that issue in isolation, I would say yes, there's probably sufficient evidence to support a 9% ROE. However, once you begin to layer on other issues that are included in the stipulation, I don't know if the stipulation would be reasonable if you kept all other provisions the same and just lowered the ROE. I mean, it truly is a package deal, and that's the way it was negotiated. And at least that's the way that I know it was, it was viewed from the Attorney General's office.
Okay, I understand. So in your view, there would be some risks involved in rejecting the stipulation.
In my view, the stipulation is reasonable and should be accepted. And if it's rejected, who knows what's going to happen? I mean, I don't know what's going to happen if it's rejected. I really don't. I don't know what decision you would go with. I don't know what appeals might come out of that. I'm not sure what would happen at that point.
Sure, I understand. The last litigated case was the 2017 case. Is that correct?
No, I think the last SPS case was 20-00238.
20, okay.
That was stipulated case.
Oh, did you say litigated?
Litigated cases.
Oh, I'm sorry. Yeah, that's probably right then.
And in your view, is there some merit to having a fully litigated case at some regular interval?
Depends what the decision of the commission is after it's fully litigated, I suppose. I mean, in my view, I'm a big proponent of settlements. I mean, I think you're dealing with people that have spent an awful lot of time on the issues. They know the issues well, and they're tough negotiators. I think we were. I think all the parties were in this case, and I think you get hopefully you get a reasonable outcome. I would probably prefer to settle cases rather than to, take my chances. I mean, as I've lost issues that I clearly should have won. And frankly, I've won issues that there's no way I should have won before commission. So I think it's very difficult to know, what any commission is going to do at any point in time. And that's why I'm a proponent of stipulations overall.
Right.
If you can get the right number. I'm not afraid to litigate either, but if you can get what you think is a reasonable stipulation, right, I think you're better off.
I guess the other side of it is if you have too many black box settlements in a row, it's kind of hard to know what's going on. I would think that you get a true picture when you do the fully litigated case.
Well, it might be hard for the commission or the hearing examiner to know what's truly going on, but I think the parties to the case have a pretty good idea of what's truly going on. I mean, I wouldn't want you to think that because we stipulated this case that we somehow did less of a review than we would otherwise do in a litigated case. In fact, we probably spent more time talking about some of the issues than we would have if we had just filed our testimony and gone to hearing and never got into a room with any of the other parties. So there is, and even in cases, there's a few cases that I've been in where we've actually settled cases prior to the interveners even filing testimony. And of course, that makes it more difficult because you or the regulatory agency has much less of a record to go on if you haven't even seen intervener testimony. But I can assure you that even in those cases, there's been an awful lot of work involved. So I think the parties are pretty much into the details of this case, and they really have been thoughtful about whether or not this stipulation is reasonable.
Great. Thank you. I appreciate it, Ms. Crane. I guess those are all the questions I can think of for now.
Okay, thank you. Thank you,
Appreciate your
Commissioner.
work.
Thank you, Commissioner.
Thank you, Commissioner. Ms. Crane, I just want to, I don't want to open a can of worms. I just want to, I pulled up the 17-00044 commission order approving and adopting the certification with modification. And I've got that up on the screen. And it looks like that there was a slight modification of the production. Can you see it?
I can, well, I see a parenthetical PTCs, including an income tax gross up, but I'm not sure where that came from. Yeah, I do see it. I do see it, but I'm just not sure where the PTC discussion starts.
Well, no, that's the actual, I was taking you to the actual decision.
Okay. Okay.
And by the commission. Because the commission in its order found that, and this is page, I don't know. This is under item 19 of the commission order. After I said I don't use the PDF page number, I'm going to have to use it. Page 10. The commission had issued some bench requests, and page 10 of the PDF, and then on page 11, it says under the modifications set out in Exhibit A.
Judge, can you start slower?
Yes, sir. Under the modifications set out in Exhibit A, if the total of the production tax credits, and it's footnoted, plus the total market revenue is greater than the requested revenue requirement for the wind plant, then SPS will provide that extra value to its New Mexico retail customers as a credit through the customer's bill. But if the value is less than the wind plant revenue requirement, SPS will absorb the shortfall in the cost recovery. Do you recall that?
I do. I'm just not sure that that's talking about quite the same issue. Is that talking about just sort of that annual look back that I had discussed earlier? And that footnote there talks, I see the PTCs are referenced in that the prior footnote, I think, right?
Yeah, in both actually. Yeah, I just wondered if, like I say, that, since you all were discussing the final order, and I can have the record reflect that it's my understanding that the parties to the case adopted the modification as proposed by the commission in that Exhibit A.
Okay. Yeah, I mean, I know I don't recall all the details, but I know there was a lot of discussion and a lot of concern with regard to the PTC issue, and I know that it was addressed.
Okay.
So hopefully, and I can go back at some point and refresh my recollection if you'd like to ask me
No,
questions.
No, I
That's-
just wanted to put the order in context and make sure that we're talking about the same thing. But I just did have one clarification with regard to the commissioner's bench request, and it's going to be referenced as right now. It's going to be referenced as bench request, hearing bench request 8. The commissioner has asked you to take the terms of the stipulation in conjunction, if necessary, with SPS, and change a 9% ROE, correct?
Yes.
Okay. But that wouldn't be the only change that occurs to that stipulation, right?
Well, that would flow through. So, actually, that's a very interesting question, because the way the model works, it's probably based on $33 million. So if you change that, your black box might just get bigger now that I think about it. I think what probably is more useful is to hold the black box where it is and to change the ROE. That will still change some other things like taxes, for example, that will flow through. But I'd probably hold the black box at the 8.5 million or wherever it is, so that the only thing really that would be isolated would be the impact of the ROE by itself.
Isn't it potentially going to, could it potentially change anything like the revenue numbers?
Well, it will change the revenue deficiency numbers. It will change how much you need. It won't change the pro forma revenue at present rate numbers, but it will change.
So it's not going to.
It will change your revenue deficiency. It'll change your revenue requirement, which then you compare to your pro forma revenues to determine how much more you need. So,
but could it potentially change your allocation?
Oh, I'm not. Yeah. Good question. I don't think so, because I don't think that the ROE, I don't think that the ROE itself would change the allocation percentages. Now, it would change the amount that was allocated to each rate class, because if the total dollar amount changes, then your amount allocated to each class is going to change. But I don't think it would change the percentages that are allocated to each class, because I don't think there are any. I don't think there are any allocators that use that would use ROE. So I think you'd be okay with that.
Okay, I guess my concern is anything that actually changes, just make sure you say what's changing. Okay.
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 And Madam Examiner, thank you. Since it's SPS's model, I think we can run the request that is the information that's being requested. And we can work with Ms. Crane on that, but we're happy to run it. Okay.
Yeah, I appreciate collaboration, and yeah, that would be great. Again, that's commission or hearing bench request number 8. Okay. Thank you, Ms. Crane. Mr. Getko, any redirect for your witness?
No, I don't have any redirect today.
Okay. Anyone have questions based upon the commissioner's questions or my questions?
Good afternoon, Your Honor. This is Ron Moss, SPS. I just have one clarification. Ms. Crane, in response to Commissioner Ellison's question, I understood you to say that the capital for all of 2024 is projected. But in fact, the future test year ends in June of 2024, correct?
Yes, I must apologize. I've been working on my PNM testimony, which gets filed tomorrow. And you're right. Your test year ends on June 30th of 2024. They're the company that has the calendar year 2024 future test year. You're right. So starting July 1 of 2023, we would get some actuals.
Right. And those projected capital additions will go through June 30th of 2024, right?
Correct. You are right. That was my mistake.
Okay, no problem. I just wanted to clear that up. The only other thing I would say, Your Honor, is that Ms. Trammell can come back to discuss PTC issues if there are further questions about that the company needs to respond to.
All right.
That's all I
Thank you,
have.
sir.
Thank you.
Okay. No further questions? Hearing none. Ms. Crane, thank you so much.
Thank you.
You're excused. Good luck on filing your testimony tomorrow.
Thank you. Thank you very much. Okay.
All right, very well. Mr. Getko, can I get, do we have any Dr. Warwich update for me?
No, nothing has changed since when we spoke yesterday, which was that there was the slot that you had proposed for availability, or maybe we did, 12:30 to 2 tomorrow.
Right, like an hour and a half that I don't think's long enough.
Right,
Okay.
and then the other.
So that means he's not going to be available till next Wednesday?
That's correct.
Okay. All right, I guess we can tentatively think about scheduling him for Wednesday morning.
Okay. I will.
Okay.
I will put that in with a erasable pen.
Okay. Gonna have to get more Post-its out. I don't have next week Post-its yet. Okay, Wednesday. Okay, thank you. Very well. We're going to go back to the SPS witness lineup at this point in time. And I just want to make sure that we're on the same page. I have that so far SPS has admitted 45 exhibits with 7 live witnesses and 6 stipulated witnesses. So when you get a chance to look at those numbers,
I don't know about the 45, Your Honor. I do know that we have presented 7 live witnesses, and looks like 1, 2, 3, 4, 5, 6. Yes, 6 have been waived thus far.
Okay, great. All right, so that brings us down to Mr. Meeks, who's not available until next week if we need him.
Correct.
So I believe that the next witness, I think I indicated earlier that I just had a few questions for witness Miranda, and if there were no questions from the commissioners, I was, I didn't have any questions for SPS witness Ripperger. The commissioners can let me know if they want to ask any questions. Mr. Ripperger supports the 2021 line loss study.
As hearing examiner, I don't have any questions for Mr. Ripperger.
Thank you, Mr. Chair. So let's go ahead and if we can have the next SPS witness.
Madam Examiner, I'm sorry. May I ask a question?
Yes.
Thank you. Regarding the bench request, we do have one question, and that is whether we need to provide new rates, or are we just interested in the revenue deficiency?
Are you talking about for Commission Exhibit 8?
Yes.
Or Commission, pardon me, hearing bench request 8.
Yes.
Commissioner Ellison, what do you prefer, sir?
I would be fine with just the high level revenue requirement.
Okay, thank you for that clarification. I appreciate it.
Thank you. But that does bring me to, and the parties can be thinking about this. So for example, I noticed over luncheon that SPS filed hearing bench request responses to bench request 1, 2, 3, and 5. And 6. So I'm just going to have to, and those witnesses who sponsored this some have already testified and some haven't testified. So what I'd like the parties to do, I was trying to wait, and I can wait until the end of the hearings and till all the witnesses have testified, except the ones that have already testified that answer these bench requests. We're not going to have an opportunity. And we have a verification, for example, from Ms. Martin as to this. But you know, my concern is I'm going to admit the responses to the commission bench request as commission exhibits. And as you know, you get the opportunity to you could object to it. You could ask me to file a response to it. But I kind of would like to have an idea whether or not anybody is going to object. That's why I've been trying to put the commission exhibits in the Dropbox so you all can see them, so that it's not a surprise to you when when I admit them. So be thinking about that. Because if you are going to object to them, then I'm going to have to make sure that I call every witness who has responded to answering the bench request so that you get an opportunity to ask the witness questions. So at this point, is there any party who thinks that they may object to responses to bench requests? And the only other, and that was prior to the hearing responses, during the hearing responses, and I believe those 2 exhibits that were utilized yesterday by Commissioner Ellison that were referenced studies provided by the Attorney General. They were referenced by Dr. Woolridge. So I'm not hearing that anybody is going to object. So like I say, you can think about it because this one just got filed from SPS, but that's something. Two other things just to clear up our record. I noticed for SPS, I noticed when I was trying to pull up Mr. Mahler's rebuttal testimony and trying to get an answer to a question that I had from Ms. Crane. I noticed all those headers were wrong in that testimony. So even though the cover sheet said rebuttal testimony, the headers all said direct testimony. So that's something that happens frequently. So I just point that out to parties that that's something else you want to look at that could cause confusion down the road whenever you're submitting that testimony, is to make sure that that the direct testimony headers, if it's rebuttal, get changed. Additionally, and as you know, I actually I don't know why specifically, but I'm feeling, at least right now, a bit more lenient on the filing of the testimony. Usually, as you know, I'm pretty much a stickler for the rules and require that testimony be comporting with the commission rules, and specifically when it comes to 1.2.2.35N, which is rebuttal evidence. And I pretty much believe that rebuttal evidence actually ought to rebut the testimony that it says it is. The rule says rebuttal evidence is evidence that tends to explain, counteract, repel, or disprove evidence submitted by another party. Evidence which is merely cumulative or could have been more properly offered in the case in chief is not proper rebuttal evidence. So a lot of this rebuttal evidence, especially the rebuttal evidence that accepts the other party's position or actually provides supplemental information not related to the direct, is not properly rebuttal evidence. We have some of that in this case. However, again, not going to ask that you refile all that testimony and separate it out. Just want to put you on notice. Rebuttal testimony needs to comply with the rule. So those are the things that I needed to address right now. Ms. Hardy, with I don't see my note, but I think you owe me some verifications.
On the bench responses, was that? I think we had talked
I'm
about
gonna-
having the witnesses verify them on the stand.
Okay, I thought there were some, if there's any that from the original, I think that is commission exhibit. Commission exhibit 5. Yeah, there's my note, verifications. Okay, so I'll rely upon you to make sure if Ms. Nemi or some subsequent witness, Mr. Lowe, answered something for hearing exhibit 5 that we address that.
Yes, thank you. We will.
Okay. All right. Okay, looks like our witness is waiting. With that, and if there's no more need for clarification, SPS has another witness.
Thank you, Your Honor. This time we call Renee Miranda.
Good afternoon, sir. You can unmute. There you are.
Good afternoon.
Not a problem. Good afternoon. Mr. Lee, would you swear the witness, please?
Yes, Your Honor. Mr. Miranda, would you raise your hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Moss.
Thank you, Your Honor. Mr. Miranda, would you state your name for the record, please?
Renee Miranda.
By whom are you employed, Mr. Miranda?
I'm employed by Excel Energy Services.
What is your position at Excel Energy Services?
I'm manager of transmission planning south.
Okay. Mr. Miranda, do you have SPS Exhibit 39 in front of you?
Yes, I do.
Okay. Can you identify that document for the record?
That is by direct testimony.
And
submitted on behalf of Southwestern Public Service Company.
Sorry, sir. Does it have attachments with it?
It does.
All right. And were the testimony and attachments prepared by you or under your direct supervision and control?
Yes.
All right. And were the answers that are reflected in SPS Exhibit 39 true and correct at the time that you provided them?
Yes.
And if you were asked the same questions today, would your answers be the same?
Yes.
Your Honor, we move for admission of SPS Exhibit 39.
Any objection to what's been identified as Mr. Miranda's direct testimony verified by him here today? Hearing no objection, SPS Exhibit 39 is admitted.
Thank you, Your Honor. Mr. Miranda, do you now have in front of you what has been marked as SPS Exhibit 40?
I do.
All right. Can you identify that record or that document for the record?
Yes, that's my supplemental testimony submitted on behalf of Southwestern Public Service Company.
And does it have attachments to it?
Yes, it does.
Were the testimony and attachments in SPS Exhibit 40 prepared by you or under your direct supervision and control?
Yes.
Were the answers true and correct at the time you provided them?
Yes.
If you were asked the same answers today, would your answers, or same questions today, would your answers be the same?
Yes.
Your Honor, SPS moves for admission of SPS Exhibit 40.
Any objection to what's been identified as Mr. Miranda's supplemental testimony, SPS Exhibit 40? Hearing no objection, SPS Exhibit 40 is admitted.
Thank you, Your Honor. Mr. Miranda, you now have in front of you what has been marked as SPS Exhibit 41.
I do.
Can you identify that document for the record?
Yes, that is my rebuttal testimony submitted on behalf of Southwestern Public Service Company.
Okay. And does this have any attachments to it?
Yes, it does.
Were the testimony and attachments prepared by you or under your direct supervision and control?
Yes.
And were the answers true and correct at the time you provided them?
Yes.
And if you were asked the same questions today, would your answers be the same?
Yes, sir.
Your Honor, SPS moves for admission of SPS Exhibit 41.
Is there any objection to what's been identified as SPS Exhibit 41? Mr. Miranda's rebuttal testimony. Hearing no objection, SPS Exhibit 41 is admitted.
Thank you, Your Honor. It's my understanding that no party reserved time to cross Mr. Miranda. So at this time, we submit him for questions from Your Honor and from the commissioners.
Very well. Thank you, Mr. Moss. Good afternoon again, Mr. Miranda. I just have a few questions, and mainly my questions have to do with asking you to try to put things in context for me. I know that your direct testimony indicates that you are the manager of Transmission Planning South and that you're employed by Excel Energy Services, correct?
Yes, ma'am.
So can I assume that there is a manager of Transmission Planning North?
That is correct.
Is there one from the east and the west?
There is manager of Transmission Planning West.
Aha. And as part of Transmission Manager South, what service areas does that encompass?
It is service areas of Southwestern Public Service Company, which includes the state of Texas, service areas of Texas and New Mexico.
Okay. Do you also get any of those sort of outlying like PPA that might be outside of the New Mexico or Texas jurisdiction that I saw on somebody's map in the past couple of days?
Can you clarify what you mean by PPA? As far as it relates to this question, I guess, is it, are you?
Well, I'm just wondering, like, is part of your purview, for example, in making sure that well, we haven't exactly talked about what you do yet, but my understanding is that part of your duties, as you set forth in your testimony, include overall management for transmission for SPS, correct?
Yes, for the transmission planning side of the business.
Right. So do you actually have to look at transmission for any of the generation or energy resources that SPS might acquire through a purchase power agreement?
I'm sorry, your answer, sir?
So the power purchase agreement, as it gets added, or the company makes a power purchase agreement, those generators are part of the model that we use to do our transmission planning, even if they reside outside of the area. As far as the actual planning of the generators, those would be done by the Southwest Power Pool as part of their GI, or the generation interconnection process.
Right. Very nice segue, because in the next part of your testimony on page 1, you say you actively participate on behalf of SPS in the Southwest Power Pool's transmission planning activities. Is that correct?
Yes, ma'am.
And I was asking some questions yesterday about that, trying to figure out just how much, if any, SPS input and control might have as part of SPP? Could you tell me a little bit about that?
So as far as the generation interconnection process, we coordinate, projects with SPP. Primarily, a lot of it has to do with having scoping calls with SPP and the customers that are trying to interconnect. We look at the interconnection points, provide guidance on if what they're proposing would be easy to gain access to their point of interconnection. SPP may also reach out to us to look at any network upgrades that are required, and probably consult with us if there's limitations that could easily be fixed on a transmission line. So it's that type of coordination that we get from SPP, but the actual analysis completed by SPP.
And for example, if the transmission planning group are you actually just dealing with costs, or are you actually planning transmission routes from proposed generation to coordinate with SPP?
Can you clarify?
Well, for example, I can recall back when with Hale and Sagamore that some of the projected costs had to do with upgrades and other even potential transmission. I don't know if I'm using the right term, but feeders or changes to SPS's system that were gonna be band-aided by SPP. And so I'm just wondering how much and what kind of interaction that the utility has with the RTO, or does the RTO get to tell you if you want to hook up your generator? We'll tell you which way to drive, which road to take, or do you have some input into the route, into the the substations, whatever you have to build?
So for the customers that are trying to interconnect to the system, I think I mentioned we have scoping calls ahead of the study process. And ahead of the study process, what the customers want to know is, what is the easiest way to access the substation? Or if is there space available at the particular substation, what kind of build out might be required? And that's where we provide guidance to make sure that the costs that they will incur could be perhaps minimized by whatever they were planning to cut there. We try to make them aware of the obstacles that may run into, especially if they're trying to cross across 4 or 5 different transmission lines to get to a particular location at the substation where they're interconnecting, or if they are building outside of our area with their understanding that they're still connecting to our system. And by that, I mean on a cooperative system that is within the SPS footprint. They may be saying, we want to connect there, with the assumption that they believe that is our transmission line. And we try to guide them to tell them that the line's not ours, or it does belong to us.
Do you get any input on like, if they're, well, for example, I know you've indicated on your study, or you've indicated in your testimony, that you say, for example, on page 13 at lines 4 and 5, SPS provided an initial study estimate for SPP's use before the issuance of the NTC, which is what, Mr. Miranda?
So we do provide cost estimates for any network upgrades that may take place as a result of generation interconnection. The Southwest Power Pool will reach out to us and they will ask for interconnection costs associated with a particular generator. And by that, I mean any equipment that needs to be added to the substation in order for the generator to bring their gen tie into that location. And then also for the network upgrades, we will also provide cost estimates as to the network upgrades that are required to interconnect those specific generators or batch of generators.
And then NTC is a notice to construct?
Yes, ma'am.
So as part of your position, Mr. Miranda, I mean, are you an out in the field person? I mean, are you actually, going to and traveling around and reviewing these projects yourself, or are you inside directing people to do that and providing more of a managerial and accounting function?
So it's more of the latter. I'm actually inside the office. And what we do is in transmission planning, we put a scope document together on what needs to be built as it comes from SPP.
And on page 25 of your direct testimony, you have a table RM4, that's the base period transmission capital addition, correct?
Yes, ma'am.
And you have several categories, but under the economic category, the company is proposing or is identifying under the space period transmission capital addition in that category, $430 million total company and 113 New Mexico retail, correct?
It's $430, not million.
It's only $113?
Yes, ma'am.
So New Mexico doesn't need much transmission addition in that particular category?
I believe this was an economic project that was put in place several years ago, and this may just be some last minute cost. I'd have to look at that, but it's not something that, I believe I'd have to go look and see which specific project that was. And I believe it is on page 26.
Hey, I don't see it, but
Page 26, it says Tuco Moreland.
oh, okay.
So that's the project they're referring to. It's a project that was put in, don't remember the exact date, but it's been one that's been in service for some time.
So was it $227 You tell me, what is the number? Is it $227 million project? $1,000 project?
Believe this is just last minute. I'd have to punt this to someone else. I'm trying to figure out where that number, but the project's been in service, and I think it may have already been through rate case and some of the last minute money.
And can you just explain to me how the projects get named? So for example, on page 29 and actually on 28, you have something called, I would call it an OPI.
So
Capital O, capital P, capital I, capital E. What is a OPI?
So OPI happens to be the money that we draw from in order to fund some of these projects. So it stands for oil patch infrastructure expansion.
Okay.
So and it's related to just projects that come up that where we draw money from to fund some of these different projects related to that oil patch infrastructure.
And when it says, and so what does Roadrunner China Draw indicate?
Yes, ma'am. So Roadrunner happens to be one of our substations down in southeast New Mexico. And China Draw is another substation. So this happens to be a 345 kV transmission line between the two substations.
And who gets to name these? Do you get to name them?
If the substations already exist and the line is going from one substation to the other, we typically just name the project if it's a transmission line on the terminal ends of that line. So that kind of implies that the line is going from one substation to another. Similar like this Roadrunner to China Draw, the line goes from Roadrunner to China Draw, and it identifies the terminal locations or the substations where that line is being terminated.
Does Roadrunner indicate somebody saw a Roadrunner go by, or is it a road, or is it a town? How do these things get named?
Yeah, so the names they come up from our siting and land rights group, and they have a process in place for naming these. They do try to get some landmarks that are close by to try to name some of these substations. But I can't tell you how Roadrunner was changed.
I want that job. Do you talk with those people and say, no, that's the wrong name. It should be something different? No,
we do. We leave the naming up to that group.
Okay. I noticed in your testimony, sir, that you have described the various project in each of the categories. I think as I previously had referred to your table RM4, the base period capital addition for the New Mexico retail was $64,840,793. Is that correct?
What page is that, man? I'm just trying to.
That's page 25 of your testimony.
Okay, I'm sorry. Can you repeat the question again?
Your table
RM4.
Right. It indicates that there is a New Mexico retail capital addition number of $64,840,793.
Yes, ma'am.
That's a lot of money, isn't it?
There's been considerable infrastructure built down in that area.
And so can you just characterize where the, or explain where the majority, or how we might think of this almost $65 million for transmission, as what it's going for? How was the money spent?
So looking at the different project categories that are here, for example, load interconnection, which is $13 million. Southeast New Mexico happens to be one of the largest growing load pockets in our company, as well as the SPP region. There's a lot of oil and gas development taking place. So just for the interconnection portion of that's $13 million. The other thing is reliability-based projects, building of transmission lines for that region. If we go back to that Roadrunner China Draw project that we discussed earlier, that is one of the major transmission lines that we built between the two substations in support of that growing load down in Southeast New Mexico.
And so that's approximately 40 million. I mean, we might as well say, what, about 2/3 of that is going to support load growth and expansion in southeastern New Mexico. Is that right?
I think that's a fair estimate.
Is there going to get to a place or time, Mr. Miranda, when there's not going to be able to be any more growth in that particular area? It's going to be totally saturated?
I'm not sure I can answer that. As far from a transmission planning standpoint, we take in the requests that come from customers and we analyze them. A lot of that is depending on the customers making the request. If the customers stop making requests, then at some point, either the system could stay stagnant, or it could gradually grow as just normal load growth. Maybe towns, small industries. I mean, will it ever stop? I'm not sure I have that level of visibility.
Well, I'm just thinking, we're talking about a finite area, right? I mean, it's not like the geographical area expands, does it?
True. It does not.
It seems like to me that there's only going to be so much opportunity for expansion in a finite area. But you're saying at this point you don't know, and I accept that. Let me ask you this. In evaluating these requests for interconnection, are you turning any down?
No, ma'am. We perform the analysis and we identify the network upgrades that are required to serve that load. We may have them wait until the network upgrades are built and then the load can get added. But as far as turning them down, we don't make that decision. The customer makes that decision whether they want to proceed with the interconnection or not.
Do you have people waiting?
We are currently have studies in the process, so they are waiting for the results of those studies to make a determination.
Well, I mean, but there's no other game in town, right? I mean, if they want to interconnect in that particular area, I mean, SPS is it, right?
Within that area that we serve, that is correct.
Okay. So the remainder on your chart, that $15 million, so the other third is in the category of system refurbishment?
Yes, ma'am.
And so is that your whole, who would that apply to?
So system refurbishment happens to be lines that are in poor condition. Let me get to my testimony just to. Those transmission lines that for the most part, I'm not talking about transmission lines. It could be breakers as well, transmission breakers that have exceeded their short circuit carrying capability. So a breaker can have a 20 kiloamp rating. And in our analysis, we can identify that if that number gets exceeded, then system refurbishment, we may go in there and have to change that breaker out.
Okay. Well, and I note that you begin the category on page 30 of your testimony, identifying specific projects. I just thought maybe you could give a general information on what that entails. Is there any particular area or plant that the refurbishments have occurred with?
So looking at if I understand the question correctly, you're referring to specific projects, is that correct?
Well, or either, are you having to spend more money, for example, to, for these under the SR category for a particular plant or a particular area in SPS's service area?
So system refurbishment takes place in the entire SPS area. These are projects that are not just for Southeast New Mexico.
Okay. But so then you're not necessarily having to so for example, I've read testimony about having to refurbish certain parts of a generation site or generation plant after a particular period of time. So I wondered if there's a corresponding link between having to do refurbishments at a particular plant or type of plant that corresponds to having to do refurbishments to transmission.
I can't speak to the refurbishments that take place at generating plants. This is my area, is the transmission planning aspect of the job.
Right. And you don't know whether or not there's some corresponding between transmission equipment and the actual generation unit. For example, if you had a generating plant that was 50 years old and the transmission line that was servicing that generating plant was also 50 years old, whether or not there would be some kind of corresponding, yeah, we need to upgrade it, we need to repair it.
I don't think there's a correlation between the two.
Okay. Yep, that's what I was asking. Okay, sir, that's what I needed to know. I thank you. I don't know if anyone else has any questions for you. Not seeing that they do. Mr. Moss, any redirect for Mr. Miranda?
Just a few questions, Your Honor.
Go ahead,
Miranda,
sir.
You were asked a few questions about growth in southeastern New Mexico. Do you recall that?
Yes, I do.
And what is causing the expansion of the transmission system in New Mexico, southeastern New Mexico?
So Southeast New Mexico, many of the oil and gas customers down there are going through an electrification of their gas compressors. It happens to be a very large load that's trying to come on, and it's trying to come on rather quickly. I think from the conversations we've had with these oil and gas companies, they're trying to meet some of the emission rules in New Mexico. So They're trying to, whatever that date they have planned, that's the biggest driver right now in southeast New Mexico.
And does the need for this transmission expansion also increase when oil and gas prices go up, for example?
It can. There are some companies that, as the gas prices go up, I don't know where that break number is, however.
Okay.
But it can.
But as the fracking has occurred in the Permian Basin over the last decade or so, have you seen a significant uptick in the request for interconnection in that area?
We have.
Okay, and if a customer comes to you and asks to interconnect, are you allowed to turn them down?
Our department does not turn down, no.
Okay, do you have an obligation to serve all the customers in your
There is
area?
yes, sir, there is an obligation to serve.
Okay, and is that when you make those interconnections that we talked about, is that investment used to serve SPS's customers?
It is investment used to the, not only for that customer, once the line gets, it's also put in for the remaining customers in that region.
Okay, and do you feel like that, if that investment helps produce more oil and gas for the economy of New Mexico?
Yes, it does.
Okay.
It does help produce.
Thank you, Your Honor. Those are all the questions I have.
And Mr. Miranda, my understanding what you were saying is you don't turn people down, but you might not be able to offer them service in the next week or next year or the next 5 years.
So the customer provides a 10-year forecast for interconnecting their load. And it has a start date. It also has a ramp rate. We will study that load based on the year and the whatever magnitude of load they're adding. They may be able to add load in the beginning of the year, at the beginning of that 10-year forecast. And then after, let's say, 3 years, transmission upgrades need to be made. So the thing is, they'll add that load and they will stop at that value until the upgrades are made. And then they can proceed to add the remainder as the time goes by within that 10-year time frame.
So they could go ahead and add immediately, but they also, depending on what it was they were seeking, there might have to wait for upgrades in transmission to occur before that could happen.
If the transmission system has capacity to serve the load, they can go ahead and proceed with the interconnection agreement and add the load. If it does not, then we would inform them of the upgrades that need to be put in place before they can add their load.
And who's responsible for paying for the upgrades necessary to have them interconnect?
Those upgrades are, they're put into, from my understanding, they put into the rate base. And they're also, now, one thing I should say that, the studies that we perform, we do coordinate these with the SPP, and the SPP will issue a notification to construct for these network upgrades. So if they issue a notification to construct, then those costs are shared by SPS, and part of it is also shared by the SPP region members.
So it's not like a line extension where potentially the customer has to kick in part of the money.
If the customer has to build the line, or they come to us and said, we want you to build the line, then that cost is charged to the customer direct.
Okay, thank you.
Your Honor, may I ask one more thing in follow up to what you just said?
Sure.
Is some of this land just empty land with no electrical facilities there at all, that you all are just extending this out to extending distribution transmission lines out to a new oil field somewhere?
There are some portions of that where we have to extend new transmission line to the locations where there is no infrastructure.
Okay, I just wanted to make that point clear, Your Honor.
Okay, thank you. Not hearing any more questions. Thank you, sir. Appreciate your time, and you're excused.
Thank you, Your Honor. Have a good day.
You too.
Your Honor, at this time, Ms. Hardy, or actually, are you going to want to question Mr. Ripperger? Because we're going to need you to make some changes here if you are.
I believe, as indicated earlier, Mr. Ripperger's testimony supports the 2021 line loss study and the radial line study. I believe I understand Mr. Ripperger's testimony. I have no questions for him. Therefore, subject to not hearing that the commission has questions for him and that the parties have not reserved any time to cross-examine Mr. Ripperger, I would allow Mr. Ripperger's testimony to be stipulated into the record.
Thank you, Your Honor. We will do that. Then at this point, Ms. Hardy is going to present Ben Elsey.
Okay. Very well. We can. Mr. Lee, what's your pleasure? Shall we take a break now, or do we want to wait a little while?
Break now would be fine.
All right. I've got 3:15. Let's take a 10-minute recess. 3:25. We'll come back with Mr. Elsey. And remember, we're streaming. Okay. Very well. I think we're back from our recess and we have another witness, Miss Hardy.
We do, Madam Examiner. SPS's next witness is Mr. Ben Elsey.
There you are. Good afternoon, Mr. Elsey.
Good afternoon, Your Honor.
Go ahead, Mr. Lee. Would you please swear Mr. Elsey in?
Yes, Your Honor. Mr. Elsey, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Miss Hardy.
Thank you. Mr. Elsey, can you please state your full name for the record?
Yes, it's Ben Ronald Elsey.
By whom are you employed and in what capacity?
I am employed by Excel Energy Services as the Director of Resource Planning and Bidding.
Mr. Elsey, do you have a document in front of you that's marked as SPS Exhibit 45?
Yes, I do.
Can you please identify that document?
Exhibit SPS 45 is my direct testimony in this case.
Was that testimony prepared by you or under your direct supervision and control?
Yes, it was.
Are there attachments to that testimony?
Yes, there are 4 attachments.
Were those attachments prepared by you or under your direct supervision?
Yes, they were.
If you were asked the questions in your direct testimony today, would the answers still be true and correct?
Yes, they would.
Your Honor, I move the admission of SPS Exhibit 45.
Any objection to what's been identified as SPS Exhibit 45, Mr. Elsey's direct testimony as verified by him here today? If there are no objections, SPS Exhibit 45 is admitted.
Thank you. Mr. Elsey, do you also have a document in front of you that is marked as SPS Exhibit 46?
Yes, I do.
Can you identify that document, please?
Yes, Exhibit SPS 46 is my rebuttal testimony in this case.
Was that testimony prepared by you or under your direct supervision and control?
Yes, it was.
Are there any attachments to that testimony?
I do not believe so, no.
If you were asked the questions in your rebuttal testimony today, would the answers still be true and correct?
Yes, they would.
Madam Examiner, I move the admission of SPS Exhibit 46.
Any objection to what's been identified as Mr. Elsey's rebuttal testimony as verified by him here today? Hearing no objection, SPS Exhibit 46 is admitted.
Thank you, Madam Examiner. I have no further questions for Mr. Elsey. He's available for cross-examination.
Okay. I do not. No, I'm wrong. Ms. Lynch.
Yes.
I see that you reserved 40 minutes for Mr. Elsey.
Yes, I hope we get through all the questions I have prepared for Elsey in 40 minutes.
All right, please go ahead.
Hearing examiner, this is Ms. Zur.
Hi, Ms. Zur.
I believe you have someone in the waiting room.
Oh, I have more than one. Thank you.
Thank you.
I need to put a note over there that says, look up at the screen. At 3, thank you. Okay, let me find the alarm first. Not alarm, timer. Okay, go ahead, Miss Lynch.
Okay, thank you. Hello, Mr. Elsey. It's nice to see you again.
Good afternoon.
Thank you. I'm going to start with some questions that were referred to you either by Brooke Trammell or expert Richard Belt.
Sure.
So did SPS evaluate the economics of continuing to operate Tolk under the current quote conservation mode through 2028?
No, SPS did not evaluate the current optimization mode through 2028. SPS did conduct the current 2,400 gigawatt hours through 2032.
Okay, that was my next question, which you may have predicted. Is there a reason why SPS did not evaluate the current conservation mode through 2028?
Yes, and I addressed that substantially in my rebuttal testimony. But in short, just for clarification, SPS did not constrain the model to run at either 2,400 gigawatt hours or 4,000 gigawatt hours. That's been alluded to over the past few days. SPS just merely sets a cap at those values. So when we evaluate the 4,000 gigawatt hours scenario through 2028, if it was more economical to run the units at 2,400 gigawatt hours, the model would have actually done that. We actually see that because Ms. Glick for Sierra Club did conduct that analysis, and I believed it showed it was $66 million more expensive on a PVRR basis through 2028.
PVR?
PVRR, present value revenue requirement.
Did your model or Ms. Glick's that looked at this conservation mode include NOx allowances?
Could you be more specific on include NOx allowances?
Include the costs related to NOx allowances that either of those scenarios would accumulate?
Under our current obligations for purchasing NOx credits, we did reach out to our environmental group, and there is no expected difference in NOx costs between the 2,400 gigawatt hour scenario or the 4,000 gigawatt hour scenario. So no, the model did not directly include those costs. However, they would be the same in both scenarios. Therefore, there'd be no difference in the cost between each scenario.
Why did SPS model Tolk at the higher generation of 4,000 gigawatt hours and not at any lower number?
Again,
for 2028?
Again, I disagree with the question. SPS did not model Tolk at 4,000 gigawatt hours. SPS merely set the cap of 4,000 gigawatt hours because that was the most economical solution. That is what the model selected.
So the scenario you used was at 4,000 gigawatt hours?
No, again, the scenario just merely sets a cap at 4,000 gigawatt hours. The model then, based on economics, dispatched the Tolk units at the most cost-effective amount of generation.
Did SPS compare the cost of that increased generation to the cost of any bids for new cleaner energy?
Oh, can you be more specific on bids?
Were any clean or renewable energy resources compared at all to the scenarios that you ran?
Yes, both scenarios included substantial amounts of new renewable generation. I don't believe I have that listed in even my direct or rebuttal testimony, but Ms. Glick does have it in her direct testimony. I believe it showed approximately 3,500 to 4,000 gigawatts of new wind generation for 2030 and approximately 1,000 megawatts, I said gigawatts, excuse me, of solar generation before 2030.
Let me see. I believe that the SPS only presented two scenarios to us. Is that correct?
That is correct.
2028 and the 2032 scenario.
That is correct, yes.
And those are the scenarios analyzed in Glick's testimony, correct?
I believe Ms. Glick also presented a third scenario in which TOC was run no more than 2,400 gigawatt hours through 2028. Again, the cost implication of that scenario was $66 million more expensive on a PVRR basis between 2023 and 2028.
Yes, thanks for Ms. Glick's analysis. Will operation of TOLC at higher capacity, meaning the 4,000 gigawatt hours per year, result in more NOx emissions?
No. Each scenario has exactly the same amount of lifetime generation. Therefore, again, as Ms. Glick confirmed earlier, the emissions are expected to be exactly the same across both scenarios.
For both the 2,400 and the 4,000 gigawatt hours?
That is correct, yes.
Can you explain why those two scenarios would result in the same amount of NOx emissions?
Yes, because if you take the generation and multiply it by the number of years in both scenarios, the answer is exactly the same.
Would you say that the NOx emissions emitted on to 2028 would be more concentrated in that time period?
Can you describe more concentrated, please?
The NOx emissions will be the same over that time period that spread from 2028 to 2032.
No, there would be under SPS's recommendation to increase the generation to 4,000 gigawatt hours. The NOx emissions between 2028 and 2032 would be less in the 4,000 gigawatt hour scenario when TOC retires in 2028.
Oh, I'm sorry, 4,000 gigawatt scenario when?
And when TOC retires in 2028.
Would there so let's step back a little bit, and I guess I would like to ask a question about annual NOx emissions. Will annual NOx emissions increase within the year or annually? That's based upon the increased 4,000 gigawatt hours per year scenario when compared to a 2,400 gigawatt hour per year scenario.
Again, SPS did not model those scenarios. That was simply a ceiling. If the units were run at 4,000 gigawatt hours compared to 2,400 gigawatt hours between 2023 and 2028, all else being equal from TOC, you would expect to see an increase of NOx emissions. And then between 2029 and 2032, you'd expect to see a decrease in NOx emissions. All else being equal over the lifetime of the TOC units, the total NOx emissions between each scenario would be exactly the same.
So will the NOx emissions be higher annually until 2028?
All else being equal under the 2028 scenario with 4,000 gigawatt hours, yes, through 2028, NOx would be higher. But again, it would be substantially less after that for lifetime emissions being exactly equal.
Correct, and that's a result of running TOC and then it retiring in 2028, correct?
Correct.
Okay, so the NOx emissions will increase annually at TOC through 2028.
Correct. If it runs up 4,000 gigawatt hours, which again is simply a ceiling, not a target.
Great. Did you listen to the testimony of witness Brooke Trammell?
I did, with the exception of a few technical difficulties. I heard most of it.
Well, were you present when she predicted the level at which SPS will operate Tolk through 2028?
Could you please refresh my mind?
She testified that she predicts SPS will operate Tolk at 4,000 gigawatt hours per year. Do you recall when she said that?
Yes, I do.
Okay, thank you. Will operation of Tolk at 4,000 gigawatt hours per year result in more greenhouse gas emissions through 2028?
The same philosophy applies to all greenhouse gases as it does to NOx specifically. Through 2028, you would expect to see an increase of Tolk, and then obviously the unit would retire 4 years earlier, and lifetime emissions would be exactly the same.
But within that period of time that Tolk is operating, it will produce more greenhouse gas emissions, correct?
Tolk will, and then other generation will not.
Oh, thank you. Did SPS incorporate any of the impacts of climate change into its modeling of Tolk?
Climate change is a very broad statement. Could you be more specific, please?
Did SPS incorporate any of the contingencies related to the impacts of climate change on water resources, for example, to the operation of Tolk?
It's my understanding this really would have been a question better for Mr. Belt, but it's my understanding that the Okwalala aquifer, with it being a reservoir essentially underground, is not particularly impacted by regional droughts. But SPS assumed equal amount of water in both scenarios.
I believe this question was referred to you by Belt. He didn't know if climate change impacts were included in the modeling that SPS ran. Let's step back. Does SPS incorporate any climate change risks into its modeling?
I think when we look at our modeling, we incorporate the New Mexico's Energy Transition Act and Renewable Portfolio Standards into our modeling. I believe that is the path that the state has taken in order to address climate change. In addition, when we model new renewable resources, we incorporate production tax credits, investment tax credits, which is again how the federal government is tackling the climate crisis.
Would you say, okay, so essentially that means, and correct me if I'm wrong, SPS doesn't include any of its own analyses of climate risks when it runs models. It doesn't put in any of its own risk assessment related to climate change?
Again, that's a very broad definition. The model we use in Compass is essentially an input-based model. If you could be maybe more specific, I could tell you whether we include those types of inputs or not.
I'm just wondering generally as I peruse the literature about climate change and risk assessment.
I'm sorry, I can't answer that question generally.
Of course, I wouldn't.
Do you have a question, Ms. Lynch?
Yes, I have many more questions. Would it be speculative to say that SPS built the current plan around gas prices remaining high?
I'm not sure I'd say speculative. SPS have a very robust process for forecasting natural gas prices.
How did it forecast natural gas prices here?
Again, could you be more specific, please?
Yes, SPS submitted this plan and did it formulate the use of Tolk around gas prices remaining high?
I will try and answer that question. I'm not sure I still 100% understand the question. But when SPS conducts economic analyses, SPS merely enters in natural gas price forecasts as an input into the model. The model then selects the most economic sources of generation to meet our demand. That would include natural gas generation, cogeneration, and renewable resources. So natural gas forecast is an input into the model. Other than that, I'm somewhat confused on the question.
I'm sorry to confuse you. We've just had multiple people testify to the impact of gas prices and the forecast of gas prices as they relate to the use of TOLC. Is that true?
Sorry, I'm still not following. Natural gas prices are an important input into an economic model. The price of natural gas will impact the dispatch of alternative fuel sources such as coal, if that's what you're asking.
Thank you. So we'll move on to compliance and SPP. Do you know whether SPS is currently experiencing any compliance issues with SPP at the current optimization plan generation levels? Meaning at its current 2,400 gigawatt hours per year?
I am not aware of any compliance issues now.
Okay, thank you. Does the current forecast that SPS uses show that gas prices are significantly lower than the forecast that was used?
So SPS's 2021 full natural gas forecast, 2022 natural gas forecast was somewhat higher than our most recent natural gas forecast. But again, just as a reminder, SPS merely sets the generation of TOC as a maximum limit. If natural gas prices are lower in reality than projected in the model, then TOC will likely run less, as Ms. Glick testified to earlier today.
Even though Ms. Trammell says that she predicts TOC to run at 4,000 gigawatt hours per year?
Yeah, so Ms. Trammell's projection is based on our economic analysis, in which Encompass ran the units at its 4,000 gigawatt hour cap. Again, I can't stress enough, that is not SPS set in 4,000 gigawatt hours in stone. That was the model showing that was the most economic solution. If other more economical solutions become available this year, next year and beyond, then the TOC units will be economically dispatched by the Southwest Power Pool.
Right, there's some variance in the use of TOLC that might exist. They so
is that a question, Ms. Lynch? Your
correct.
commentaries become your commentary on the answers is becoming a bit frustrating for me. I would direct you specifically to ask questions.
Okay. So has SPP claimed that SPS is limiting or withholding generation currently?
No, the Southwest Power Pool have not made that claim. In order to cap the TOC generators at 2,400 gigawatt hours, SPS produced substantial documentation to the independent market monitor to show why it was prudent to restrict the generation of TOC to no more than 2,400 gigawatt hours. That included the water studies that Mr. Richard Bell produced.
Okay, thank you. Earlier you said that the forecast for natural gas prices varied somewhat. I'm wondering what you mean by somewhat. Do you mean 10%? Do you mean 50%?
I don't have the numbers in front of me right now. I know the short-term projection did fall. Long-term projections stayed fairly consistent. What I think it is pointing to is the fact that there's increased volatility in natural gas price forecasts. So it is very prudent for a hedge against increased volatility to increase the cap to 4,000 gigawatt hours per year, even if TOC does not run that frequently if natural gas prices stay low.
In your rebuttal testimony, you discussed that substantial supporting documentation would be needed to seek approval from SPP and the independent market monitor for TOC to be operated under its current proposed mode of 4,000 gigawatt hours per year. I apologize. Under the current mode, the conservation or optimization plan, did SPS have to seek these approvals from SPP and the IMM for its current operation of TOC?
Could you point me to a page reference, please?
Let's see. It's in your rebuttal. I believe it's pages 4 and 5.
Okay. Do you mind restating the question now on pages 4 and 5?
I'm going to navigate there myself as these are prepared questions. I'm sorry, it's taking me a little bit of time to navigate here. Oops. Could you look at the bottom of page 4?
I'm on page 4.
Okay, and there you say, as a member of the SPP, SPS cannot simply withhold the availability of its generating units without substantial supporting documentation. Can you explain what is this substantial supporting documentation?
Yes, it's my understanding that our employees in commercial operations, market operations, would present the independent market monitor, the water studies that showed we could only run at 2,400 gigawatt hours if we were to maintain a 2032 retirement date.
So would you necessarily call this substantial?
I have not seen each.
Would it be a big burden for SPS to produce this information to SPP?
I have not physically seen the information. All I can speculate is we have many, many years of historical water data. I would speculate that that supported the documentation, but I do not know.
Okay, thank you. So in your opinion, if the PRC limited new O&M costs at toll to 2,400 gigawatt hours as the most prudent approach, you could presumably share that with SPP, correct?
We could certainly share that data with SPP and the independent market monitor. I couldn't speculate on how they would react or how they would respond to such data.
And it's true that a withholding of generation has never been determined by SPP under the current operation of TOLC.
No, that's correct. But just a quick reminder, our current operation also aligns with the projected retirement date. What you're suggesting would be a disconnect between the optimization plan of 2,400 gigawatt hours and the projected retirement date.
That scenario assumes no additional renewable energy is brought online, correct?
No, that's not correct. I testified earlier that each scenario included substantial amounts of new renewable generation.
Can you please turn to page 5 of your rebuttal?
Yes, I'm there.
Great. And can you read lines 8 through 12?
In keeping with the maximum annual generation limits described above, SPS modeled 2 alternative scenarios in the Encompass production cost model. Scenario 1 included a maximum annual generation limit of 4,000 gigawatt hours and a 2028 retirement date. In scenario 2, included a maximum annual generation limit of 2,400 gigawatt hours and a 2032 retirement date for the TOC units.
Those are the 2 scenarios presented, correct?
That is correct. In each of those scenarios included new renewable generation.
Were those scenarios conducted based upon the assumption that SPS must use all of the economical water available to it?
No. As I testified to earlier, each scenario merely sets the cap of the generation to correspond with the maximum amount of water available. There was no requirement for either scenario to run at either 4,000 gigawatt hours or 2,400 gigawatt hours per year. The model only chose to do that because it was the most economical solution.
Correct. So is it correct to say then that the most economical operation of TOLC will result in the depletion of the economical water available to it?
Yes, based on the economic model assumptions that we used, running TOLC at 4,000 gigawatt hours a year through 2028 would save customers approximately $120 million on a PVRR basis.
But you didn't answer the question. Wait, you didn't
Thank
answer
you.
the question, Mr. Elsey. What, if anything, does the analysis have to do with the economic water usage?
So the analysis set the cap of each generating scenario. So each scenario had a generation limit that corresponded with the maximum availability of economic water. In other words, both scenarios, if the TOLC units were dispatched at their maximum possible ceiling, would get down to that 40-foot level of economic water Mr. Bell described yesterday.
Okay, so it was the amount of water of economic water usage was actually included as, I don't know what you want to call it, as a factor in the modeling.
Yes, Your Honor, it was merely set as a ceiling. In other words, in either scenario, you couldn't produce more generation than you had economically available water.
So then basically, if I want to think about it this way, then I can see the the gigawatt hour numbers as corresponding to the utilization of the economic water limit also.
That's correct. If the scenario reached that generation, yes, that is correct.
Okay, thank you. I had stopped your time, Ms. Lynch. I'll start it back. You have 10 minutes.
Thank you. Can you please turn to page 9 of your rebuttal?
Sure, I'm there.
Okay. And I wish I had the line number, but at page 9, you state that, quote, SPS does not incur any cost to withdraw the water it uses at Tolk. Is that true?
Yes, that is true. SPS owns the well field, as Mr. Belt testified to yesterday. So there is no direct cost of purchasing water per se on, for example, a gallon basis.
So does this mean that you get the water for free?
I mean, we have to extract the water, but again, there is no direct cost of the water. We own the water rights.
And I think we had some conversation yesterday about this, but well, then what would make the water uneconomical for SPS at this point?
Again, we would still have to extract the water. So there's no direct cost for the water on, as example, a gallon basis, but we would still have to drill new wells in order to maintain production of that water.
Okay. In your rebuttal at page 10, you suggest or state that NOx allowances could become cost adders to reflect the cost of purchasing NOx credits.
Yes, I do.
Are cost adders optional when you present a bid to dispatch Tolk?
Could I maybe ask you to be just slightly more specific on that question, please?
When you present a bid to SPS to dispatch Tolk, are the cost adders something that you can choose to present? Meaning, are they optional or must they be included in a bid?
I don't know the answer to whether they're mandatory or not. What I can say, and I think we're on the record as saying through the dependency of this hearing, is that if the good neighbor rule is implemented in Texas and we do incur additional NOx costs, then we will add an adder to the total generating offer price.
So the effect of the good neighbor rule would mean that these costs would be required for you or SPS when you present a bid to dispatch Tolk.
If I could perhaps rephrase that and answer slightly differently, and let me know if I don't answer your question. If the good neighbor rule was implemented, we would incorporate the additional cost of NOx credits while offering the Tolk generators into the Southwest Power Pool market during NOx season, correct?
Was that modeled? The inclusion of these NOx cost adders?
No, as we've mentioned earlier during this hearing, currently the good neighbor rule has been stayed. If the good neighbor rule is implemented, we would apply those adders.
Thank you. Would you consider that a significant cost to SPS for operating Tolk at 4,000 gigawatt hours per year?
No, again, I need to clarify the question because I think it's a very important point that we appear to be losing in translation. And SPS did not require the Tolk units to run at 4,000 gigawatt hours a year. The Tolk units will be continued to be dispatched economically. Therefore, as it was extremely costly to run Tolk with a NOx adder, then the Tolk units would simply not run we would run alternative sources of lower cost generation.
Correct. You were present for Ms. Trammell's testimony.
Yes, I was.
Thank you. In case number 19-00170 UT, SPS agreed to provide identified replacement resources for Tolk. Did SPS ever provide those for Tolk?
Madam Examiner, I'm going to object to this question to the extent that it's assuming facts that aren't in evidence and is beyond Mr. Elsie's testimony.
I don't know, as since he's the resource witness, that it's not helpful. I think you can answer the question. Are you familiar, Mr. Elsie, are you familiar with the 19170 SPS rate case?
I am familiar to a degree. I do not recall that particular requirement. I do recall that we were required to submit a updated Tolk analysis as part of our 2021 IRP, which we did in approximately July of 2021.
Is that the most recent update and analysis on Tolk, other than Tolk generally, that's been provided to the commission?
Up to this analysis that was submitted in this rate case, I believe the 2021 IRP analysis was the most recent completely updated analysis. I believe there was an update of the water model in the last rate case. I can't quite recall when that was.
In 20-00238?
It would have been. So yes, that would have predated the 2021 IRP, excuse me. So yes, Your Honor, just to clarify, the 2021 IRP analysis was the most recent Tolk analysis until this proceeding.
Okay. All right, I'll start your time back. Ms. Lynch, you got 4 minutes.
Thank you. I would ask that administrative notice be taken of 19-00170.
Of what? The final order?
Yes.
Okay. Any objection to taking administrative notice of case number 19-00170? It was a SPS rate case settled by stipulation, if I recall. Hearing no objection, I will take administrative notice of that case. Go ahead.
Thank you. All right. So does operating Tolk at 4,000 gigawatt hours per year and extending the lives of the Nichols units possibly decrease the percent of renewable energy in the current SPS mix?
No, it does not. So renewable energy is dispatched with zero cost. So it is always going to be higher in a dispatch stack than any coal or gas generation. So extending the Nichols units will not displace any existing renewable energy generation because renewable energy has a lower production cost.
So then would you say that by in your estimation by 2025, how much of the SPS generation will be from renewable resources? What percent?
Yes, so currently SPS actually has about 40% renewable energy, which is approximately twice the RPS requirement in New Mexico. So we're ahead of the game there. In our last few RPS cases, we've actually requested an incentive to try and increase that amount and get even further ahead. Like I said, right now we're currently at 40%. We will be filing CCNs later this year to add an additional 418 megawatts of solar generation, which again will further increase our current 40% metric.
And the proposal for for Tolk and the extensions of the lives of nickels will not decrease the percentage of renewable energy being generated now by SPS?
No, absolutely not. As I just explained, the gas and coal units will be further down in the stack than any renewable energy. So we do not see gas generation or coal generation displacing renewable generation. So no, it will not lower the percentage of energy mix.
Interesting. Did SPS model a range of prices based on whether they are under your NOx allowance allocation?
Could you be more specific, please?
Did SPS model a range of scenarios based upon whether the good neighbor rule would go into effect?
No, as I testified earlier, SPS did not model the good neighbor rule. If the good neighbor rule is implemented, we would then apply the cost adder to the Tolk units.
And did you compare, or SPS compare, the cost effectiveness of extending nickels or adding generation at Tolk to bids for new clean energy?
You lost me somewhat in the question when you said adding generation at Tolk. Could I maybe get you to clarify that part of the question, please?
Going from the 2,400 gigawatt hours per year to the 4,000 gigawatt hours per year until 2028.
Yes, again, as I stated, SPS included significant amounts of new renewable generation in its Compass analysis when evaluating the Tolk scenarios.
Did you use any of the
Last
recent
question.
bids from the recent RFP for your
No,
models?
No, SPS filed its direct testimony and its analysis towards the end of last year. I don't recall the exact date. The bids from the RFP were not even received until February the 28th of 2023.
Okay, thank
Okay,
you. Those
your
are
time.
all my questions.
Very well. I do not believe that there was any other party. I've got a few questions for you. Mr. Elsey, welcome. I've got the stipulation up, I think, here on the share screen, and was just trying to find.
Sorry to interrupt,
Yes, sir.
Joanna. I only see a very nice picture of a tree right now.
That's my walking tree from Peru. It says I'm sharing the screen. I guess I'm sharing the screen, but not my not the screen I want to share. I don't know. It might be more interesting if we talk about trying to find what I'm looking for in the tree. You know, one of those can you identify pictures. How about now?
That's better. Thank you, Your Honor.
Okay. And I'm just trying to find, was there? I thought there was, now I can't find it. Was there a specific modification plan agreed to in the stipulation?
It's my understanding, and I'm certainly not a lawyer, that the commission has never approved the optimization plan in terms of the number of gigawatt hours per year, either in previous cases. And I don't believe in this case SPS is requesting that. I believe SPS has merely provided that information to support the change in the depreciation date to 2028. But I may be incorrect there.
Because we've had so much testimony on on modifying its operational plan, and there are, various provisions of the stipulation that refer to TOLC, and right now we're looking at the self-commitment, which in essence, Section 15 basically limits SPS's use to an economic dispatch situation, doesn't it, Mr. Elsey?
Yes, Your Honor.
Since it sounds like you listened to Ms. Glick's testimony earlier today, am I correct that you agree with her updated opinion based on current gas prices that potentially SPP could decide that TOLC was not as economic if gas prices are lower?
Yes, generally speaking, I do agree with Ms. Glick. If natural gas prices are lower, then it's more likely that the TOLC units will run or will generate less. I think that is a fair statement.
Okay, and I also wanted to talk about, since you were listening to her testimony, Ms. Glick has included in her direct testimony a claim that I guess with part of the analysis that this is going to cause SPS to have stranded new resources because the generation assets that were modeled included so many megawatts of new gas plant?
I recall, excuse me, I do recall the statement by Ms. Glick. I would respectfully disagree. In this case, SPS is not requesting any new generating resources. SPS is going to file its IRP on October the 15th of this year, 1 year ahead of schedule, to identify the resources that will replace TOLC. The resources that will replace TOLC will conform with the Energy Transition Act renewable portfolio standards in New Mexico. SPS intends to present at least 2 or 3 scenarios per our discussions, public stakeholder discussions. They would include no new gas generation at all, or potentially some scenarios in which we model new gas generation on the assumption it will be converted to carbon-free by the end of the year 2044. Those scenarios would include carbon capture or the potential for hydrogen blending.
You're not going to come in with a new extension for TOLC, are you?
I think that's very unlikely.
Well, I'm just sort of chuckling because I thought we dealt with a retirement last time, and then now it's changed. So that's sort of a question that I have, and that maybe you can answer, sir. That why is it that it seems like when there's a plan for abandonment for a particular plant that it's not final?
That's a great question, and I wish it was that simple. I've been working on the TOLC retirement for at least 8 years now, and I'm ready for this retirement to take place, to be honest. But retiring generation in resource planning in general is extremely complex, and several critical inputs change on a frequent basis. We have previously, or I had previously, supported retiring TOLC in 2032 with a 2,400 gigawatt hour cap. In this case, there was two real defining factors that changed the economic analysis. One was being the increase in natural gas prices. That was somewhat unforeseen or wasn't projected in our modeling. And then the other was the passage of the Inflation Reduction Act. What the IRA did was it extended production tax credits for wind generation, and it also introduced production tax credits for solar generation. And as you've mentioned a couple of times over these last few days, is it also gave a transferability for production tax credits option. So now what we see is replacement resources, renewable resources, energy storage resources are now significantly lower cost in the latter part of the decade than they were during our 2021 analysis. So that's definitely one of the reasons why we think it's now most economical to actually retire TOC even earlier than we previously have suggested.
But is it this, I mean, is it common in the generation resource understanding and community that, and from your planning perspective, when you plan to have a particular resource retired and abandoned, when you've calculated its useful life, you've depreciated it, it's done its job, and you say, okay, it's gonna be retired, to not retire it. Is that usual or is it unusual?
I don't think it's particularly unusual, if I'm honest, in my experience. Okay. Again, we are constantly evaluating what's in our customers' best interest. So, we have the TOC retirement date set as 2032. The situation changed where natural gas prices increased. The IRA was passed. We, in my opinion, prudently reevaluated the analysis and discovered it would save customers $119 million to retire TOC even earlier. So we're going to continue to make that effort on all of our generation and make sure we continue to act in our customers' best interests.
Well, it's also in the interest of your shareholders also, right? And you want to make money.
We do. I honestly don't think in this particular case, retiring TOC 4 years early was necessarily driven by any shareholder impact. It was really based on potential customer savings. And then also, again, there's some environmental impacts of retiring generation earlier and having renewable generation online sooner.
But I'm just saying in general, I mean, in all of the planning and operations of the company, I mean, the goal of the company is to make money, isn't it?
That is the goal of most companies, yes, including Xcel Energy. I would hope that isn't our sole goal.
Oh, no, I'm not trying to suggest that it is, sir. I'm just saying that in addition to trying to save the customers money and other goals that you might have, we need to keep in mind that it's not a 501c3, right? I mean, correct?
That's a fair point, Your Honor.
Okay. Also, I'm assuming that your modeling includes purchase power agreements and other sources?
Yes, it does.
Do you ever see potentially a shift into less company-owned generation and more generation from purchase power agreements?
I'm not sure I can answer that question. What I can say is there's definitely been a shift in recent years, and the New Mexico IRP rules and the RPS rules require competitive solicitations. So we will go out and issue a competitive RFP that the company can bid into, but also independent PPAs can also bid into. And really then we can look at what's the lowest cost for our customers and what's the highest quality projects for our customers also. So I don't know if that necessarily answers your question, but it certainly demonstrates a level playing field between the company and potential PPAs.
Well, I guess I'd like to look at your testimony on page 5, and you're answering the question on lines 15 and 16 of page 4 about summarizing your key points. And I'm specifically looking beginning at line 3, where you're talking about SPS's changing capacity position, including the reserve margins from SPP, the expected load growth on the SPS system, which I think we've heard about both of those things. And I just would like a clarification on this last part, changing resource adequacy requirements. Specifically, sir, what do you mean by that?
Yes, Your Honor, and I was following kind of the words, but I didn't find the page reference. Do you mind just restating?
No, it's page 5 of your direct testimony. And I'm looking specifically at line 6.
Yes, and if you can just bear with me, I'm going to go to another page in my direct testimony where I think I expand on that. If you can just give me a few seconds. If you could please turn to page 24 on line 14.
Okay, so then what you mean by changing resource adequacy requirements on line 6 relates to SPP's devaluation of renewable generation?
So I think what I'm referring to on changing resource adequacy requirements is broader than just SPP's implementation of ELCC. There's several changes that the SPP are looking at implementing in the next few years. ELCC for renewable accreditation being one, performance-based accreditation for thermal resources being another, the introduction of a winter resource adequacy being a third example. Your Honor, what we've seen recently is, with Winter Storm Uri, but just also the transition to renewable energy across the country, not just SPS or the SPP, is an increased focus on ensuring resource adequacy as we transition away from coal and gas generation to more intermittent renewable heavy portfolio.
Okay. Well, it makes it a bit more challenging, doesn't it?
It makes it extremely challenging. This is one of the reasons why I believe I state in my testimony, and I can find it, is why we firmly believe the planning reserve margin it is absolutely not a target. The planning reserve margin is a minimum requirement we should plan to. And because of the increased uncertainty on both the resources side and the potential for load growth, it really would be prudent to plan for this uncertainty and really plan above a 15% PRM.
A 15%?
PRM, planning reserve margin.
Right. I think you give some testimony on pages 7 and 8 generally, and then you keep going on page 8.
Yes, that's correct.
So you think it's that the potential as we transition into lower and no carbon is going to require a higher reserve margin to ensure service?
The Southwest Power Pool, and in fact, maybe if I could just backtrack, I am a member of the Supply Adequacy Working Group within the Southwest Power Pool. Mr. Cooley provided an introduction to some of the working groups yesterday. The Southwest Power Pool Supply Adequacy Working Group gave us serious suggestions that the planning reserve margin will likely increase again at some point in the future. That is not necessarily just because of the transition to additional renewables. There's also additional considerations, correlated outages being one, which we encouraged during Winter Storm Uri, and in just a general focus towards all things resource adequacy.
So it's kind of like a rate case. They're gonna increase the reserve margin in steps. It's going to go up to 15%, and then is it a short period of time? It's going to go up again.
We expect to see an increase in the summer planning reserve margin within the next 5 years. I would say is extremely likely. Yes.
Do you know what it's going to potentially be?
No, in our IRP process, we have suggested that we model 2 different scenarios for planning reserve margin. We've suggested we continue to model the existing 15% planning reserve margin to establish a baseline. We have also suggested we evaluate an 18% planning reserve margin in the summer with a potential 20% planning reserve margin in the winter. That is somewhat speculative. That's just based on conversations with other members of the Supply Adequacy Working Group.
But isn't your SPS New Mexico peak? I mean, aren't you a summer peaker?
We are currently a summer peaker. There are some utilities within the Southwest Power Pool that are winter peakers, so it would certainly impact them more. But what I think is a very interesting dynamic is as you start adding more solar generation to the portfolio, what you start considering is our net peak of renewables. And to maybe kind of elaborate on that, as we add more solar generation to the portfolio, solar is a very good summer capacity resource. So we start seeing that solar serving our summer peak. However, it does very little to our winter peak. So we start having to care more about net peak of renewables.
And I know that you're testifying regarding your Encompass model at pages 15 and 16. And you're talking about your solar resources. So I had a question about your testimony on page 18. You're answering the question posed at line 6 on page 17. Can you describe SPS's demand and energy planning forecast? And I'd like for you to explain to me on line 1, you say a conservative approach to generation planning resource would be to design a system capable of serving only the most likely oil-related growth, but no more than the most likely load growth. So in the planning context, when you're looking at these, you have you have a conservative, moderate, and an extreme viewpoint when you're doing resource planning?
For this analysis, we modeled two different load growth scenarios. One was a conservative scenario, which we're calling the financial forecast. The company typically uses the financial forecast for earnings projections. The problem with using the financial forecast for resource planning is you cannot react quick enough for potential load growth. As Mr. Miranda was just testifying to, we're seeing huge loads growth in Southeast New Mexico, and we obviously have an obligation to serve that load growth. So we also take another lens where we look at it through the planning forecast. With the planning forecast, we assume some relatively moderate load growth within Southeast New Mexico. I think between now and approximately 2030, there's about an extra 600 megawatts of additional demand. I would like to exercise caution there. That is by no means a very optimistic or aggressive forecast. We have seen some, quite frankly, staggering projections of load growth in the Permian Basin. Mr. Miranda again was testifying. We see, yes, there's some additional expansion of the oil field, but what we typically see now is the electrification of the oil field. And again, some of those numbers would far, far exceed our planning forecast.
And again, I'm just trying to understand the benchmark between what. So conservative is just building what you're sure, or planning for what you're sure is going to happen.
Broadly speaking, yes, that's correct.
Okay. And then what would be a different approach that could be utilized?
So right now, the approach we are taking is just to use a probability distribution. In other words, we see that load growth and we assume one standard deviation increase on our kind of conservative forecast. Historically, we felt like that was a fair reflection of potential load growth. With these very, very large customer requests we're starting to see in, simply just assuming one standard deviation is probably no longer enough. In our IRP forecast, we're actually proposing 3 different load growth scenarios. We're proposing the same 2 we're presenting here, the financial forecast and the planning forecast. We're also proposing a third load forecast, which we are calling an electrification and emerging technologies load forecast. And that would include substantial load growth in the Permian Basin based on our contact and discussions with our very large customers and what they are telling us they expect to bring online in the next decade and beyond.
So how does that potentially change your testimony at page 19, where you're talking about how much additional generation that you might have to have? You're referring to additional accredited capacity, just because of the planning reserve margin going from 12% to 15% by SPP. You're saying 123 megawatts in 2023 and 136 by 2027. Can you characterize how you think that this projected load growth could affect those numbers?
Yes, so the increases that you're discussing on the top of page 19 were driven by the planning reserve margin increasing from 12 to 15%. Yes. Our reaction, considering we needed to immediately increase our PRM effective this year, was the decision to extend the Nichols 2 and Nickel 1 generating units through 28 and 27. That ensured we had enough capacity within the Southwest Power Pool to meet these increased capacity needs through the PRM increase.
So then it's further on then in your testimony, for example, on page 22 in your graph, is some of that projected capacity based on these, what you're anticipating is all this load growth?
Yes, so if I can maybe just defer you back to page 21. On 21, the capacity position shown in the table there was our planning forecast, so the one standard deviation increase. Going on to page 22 in table BRE3, this did include some of the additional growth, not only from the oil field and electrification, but also from other high energy customers we've had contact with. This includes clean aviation fuels, cryptocurrency mining, and other emerging technologies, we would call them. In order to solve this capacity need shown in table BRE3, again, this includes the extension of Nichols 2 and Nichols 1. This capacity need would be greater without those extensions. And we also issued an RFP in November of 2022 as an update to our 2021 IRP to procure new generation to meet this need. As I mentioned earlier, that new generation includes 418 megawatts of new solar generation that would come online between 2026 and 2027.
Well, it seems as if the increased load and request for interconnection in southeastern New Mexico is not new, right?
I would say the increased load in southeast New Mexico is not new in itself, but I think maybe the need has changed. Historically, when we look at load growth in the oil and gas field, it was very cyclical and it was based on the price of oil. During times of high oil prices, you would see expansion of the oil field and then contraction during low prices. What I think is different this go around is the fact that many of these very large commercial industrial consumers, or excuse me, companies, have their own carbon reduction goals. So they're looking to electrify their own operations. So that really isn't necessarily as directly impacted with oil prices. So we're continuing to see that load growth.
So basically, it's your potential customers have changed how what their needs are and how they're approaching their service with SPS. Is that right?
Exactly. It's not just the energy industry that is looking to decarbonize. It is also, some of our main customers, oil and gas, are also looking to decarbonize their own operations. And then also, obviously, the transport industry with the potential for an explosion of electric vehicles, part of the phrase in there. We do see, the potential for significant load growth.
You're not making a battery reference, are you, Mr. Elsey? Besides, I've been reading recently that there's like some whole new technology that's going to come about that's going to have an alternative type of battery. Is that right?
We are certainly looking at all types of chemistry for battery energy storage. What we typically see today in terms of commercially viable battery energy storage is lithium-ion batteries. They typically have a duration of 4 to 8 hours in terms of what's economical. Going forward, as we start looking beyond 2030 and striving towards New Mexico's carbon reduction goals in the 2040s, we're going to need some long duration energy storage. XL Energy, I believe, are actually doing 2 pilot programs where we'll start exploring the potential for 100-hour battery energy storage. That would be a different type of battery than lithium ion.
Because isn't it the lithium ion that they catch on fire, right?
But come on.
I don't know who's just talking, but you might want to might be you, Miss Lynch. Go ahead.
Just
Go ahead,
to
sir.
answer, sorry, just to answer that question, we have not experienced any lithium-ion batteries catching on fire that I'm aware of within the Southwest Power Pool.
Well, isn't that the one though that like when you're on the airplane that you're not supposed to like put in the baggage that goes in the hold of the plane?
I don't pretend to know why we do what we have to do on airlines, I'm afraid.
Okay, I just read something recently that actually was some scientific paper that was saying that, you know, they think that they had come up with a reason for there were fractures in the coating on something that was allowing the positive and the negative to come. But anyway, be that as it may, I believe, sir, that's all the questions that I had for you. However, I also think that that the chairman has some questions for you. So I will stop talking and chairman, sir, do you have questions for Mr. Elsey?
I do. Thank you.
Go ahead, sir.
So apologies, Mr. Elsey, I can't avoid asking the resource planner a question or two.
I didn't expect anything less, Mr. Chair.
So let's start on page 35 of your direct testimony. Can you just walk us through what table BRE4 is?
Absolutely. So as I was just describing to the hearing examiner, this table is based on our planning forecast, so our higher load forecast. What we see on the first row is the costs of running tow through 2032 with a maximum generation cap of 2,400 gigawatt hours per year. Between 2023 and 2028, on a present value revenue requirement basis, the total system cost would be approximately $5.1 billion. Between 2023 and 2042, the total system cost on a PVRR basis would be $12.5 billion. On the next row, we then compare that to a 2028 retirement operating at 4,000 gigawatt hours per year, in which we see the total system costs on a PVRR basis are $66 million less. And then between 2023 and 2042, the $119 million less that I mentioned earlier.
Thank you. And then those numbers, the NPV RRs are also shown on your attachments, right? BRE 1, 2, 3, and 4.
Yes, I believe so. And they show them on an annual basis.
Right. So, and then the annual basis is the annual cost that then gets discounted. Is that WACC, the discount rate?
I think we used an approximation of the WACC at 7% after tax discount rate.
Okay. So then just broadly, what I see in here is two sensitivities, the load sensitivity that you've already talked about, and then a wind price sensitivity. And my question is, are there any other sensitivities?
These are the only sensitivities we ran for this particular analysis.
And then within the sensitivities, are there any analysis of, say, gas price risk?
We did not do a gas price sensitivity for this particular analysis, mainly because the way we do gas price sensitivities is changing the load growth assumptions and what we found to be the gas price increase assumptions. What we found in this particular analysis, this was driven by short-term natural gas prices in which we used NYMEX actively traded market data which isn't particularly changed by natural gas price sensitivities.
And is that what you would normally do for, say, an IRP analysis?
No, for an IRP analysis, we would typically do a sensitivity on natural gas prices, both low and high. And that's because then you typically are looking at a much longer period where the natural gas price is more uncertain.
Yeah, thank you. And then sounds like you were listening to my conversation with Ms. Glick this morning. I was trying to understand the environment for how these NOx allowances are going to be priced. Do you have any insight into what drives the price of a NOx allowance?
I do not, sir.
And then I was listening to your conversation with Ms. Lynch earlier, and I'll give you what I heard. So hopefully I heard it correctly, that NOx emissions over the period will be the same, because it's either going to be more upfront or more upfront and less in the back, or just a constant rate over the period. I was surprised to hear that that has no impact on the NPV-RR.
I'm not sure that was the intent of my answer, if that's how it came across. So what we actually said was, under the current NOx requirements, we believe we have enough credits, regardless of where we operate at 2,400 gigawatt hours per year or 4,000 gigawatt hours per year. If the Good Neighbor rule is implemented and we are required to purchase additional NOx credits, then that would certainly impact the PVRR analysis.
Okay, so I mean, shortcut of what I heard you just say is the way to reconcile what I heard earlier is that basically the price of allowances is zero, because the modeling assumption was no Good Neighbor Fund rule, and if you do need them, you have some on the shelf at the moment.
Maybe if I could slightly rephrase that, based on current CASPER requirements, we have enough credits under each scenario. Under the Good Neighbor rule, we would likely need to purchase additional credits under both scenarios.
Okay, so then for me, that kind of begs the question, why the stipulation has a paragraph that defines recovery of NOx allowance costs if the modeling assumption is that there aren't any.
I'm not overly privy to the discussions that were had for the stipulation. My understanding is, if the Good Neighbor rule is implemented, it may, at certain occasions, still be more economical to purchase additional NOx than rely upon alternative sources of generation. And if it is more economical, that may result in more than $110,000 of NOx allowance costs.
Okay, so I mean, I guess what I'm exploring here is just kind of the asymmetry of the analysis that leads us to believe that, you know, raising the limit on TOLC for a shorter period of time is economic for customers, but there might be the risk that there is cost in the future. So let's address that for the company by putting recovery in the stipulation.
I'm not sure I completely agree with that premise. I think if we are subject to NOx costs and it is still more economical to run the TOLC units, then we shall receive coverage, or that's what this requirement is trying to get.
Yeah, I guess where I'm getting at is if there aren't any NOx costs in the analysis presented in the attachments, BRE 1 through 4, and then that, when I read your testimony, that's the proof that this is a better deal for customers. Would the view of whether it's a better deal for customers change if there are NOx costs in the period?
You would, if you had NOx costs, then you would have to reevaluate the situation. So you would have to establish whether it was still lower cost to run the TOLC units with the NOx adder, as opposed to run alternative sources of generation. In other words, having a higher limit couldn't result in additional cost for customers.
So then does the stipulation give the commission the opportunity to reevaluate this situation?
Again, that's really outside of my testimony.
Okay, thank you. Yeah, I've been in your chair before, so I know what you're talking about. Then another thing that just kind of struck me when I was reading your testimony is the rebuttal testimony, bottom of page 12 through 13. I mean, what?
Yes.
I mean, what I did here is an acknowledgement that SPS is going to look at the requirements of the law, including the zero carbon requirement in 2045 in this IRP. So that's an improvement over what I heard earlier this week. But the other bit of that is in the law that's cited in the footnote on page 12. The full reading of paragraph 6 is, not only the zero carbon requirement in 2045, but reasonable and consistent progress shall be made over time towards this requirement. So just curious, what is your definition of reasonable and consistent?
Yeah, and I think I looked at that part over time. I think we're looking between now and 2045. Are we making progress towards the ultimate goal of, that we share, which is carbon free by 2045? I think over time, when you look at that, we have absolutely zero incremental carbon emissions. It's the same in both scenarios. What retiring toke at the end of 2028 as opposed to 2032 achieves is the fact that we will almost certainly be required to build a very large build out of renewable resources towards the end of this decade. We are currently at approximately 40% renewable generation. To replace the capacity of toke will likely see us far exceed the 50% requirement of the RPS.
Yes, I guess my question hinges more on what does consistent mean to you?
Well, again, I think, consistently we are not over time adding additional carbon to the atmosphere. And what we are doing is we are consistently procuring new renewable generation to increase that percentage until we transition to a carbon-free goal.
Okay, just when I read your testimony, it seemed your dismissal of Mr. Long's opinion was a little harsh when I read the law. So I just wanted to get to understanding why you thought that was okay.
It certainly wasn't intended to come across as dismissive, if that's how it reads.
Well, no, it wasn't dismissive. It's just when I read reasonable and consistent over time, and the law was passed in 2019, I think maybe even if you don't agree with it, it's okay to see that somebody else sees that as, hey, CO2 emissions should reduce over the period.
I think, if I recall, part of the issue as we were addressing rebuttal testimony was I think there was an incorrect citation in Mr. Long's testimony. I believe at the time he was referring to the incentive requirement, and that may be why we have slightly, I don't want to say harsh language, I know you've already confirmed it wasn't, but maybe a different interpretation at the time.
Okay, thank you. And then in addition to that requirement, Excel has an interim goal of 2030. I was wondering if you include meeting the company's goals in the analysis.
Yes, so I've mentioned several times on this call, in our modeling, we have a very large build out of renewable resources. We are currently at 40%. As I mentioned earlier, we've actually requested an incentive to achieve the 40% goal as early as 2022. Our expectation when you come to replace taupe towards the end of this decade, we will very, very likely far exceed the 50% requirement that is required in 2030.
Yeah, but when I read the company's goal, just going to their sustainability reports on the webpage, it's expressed in CO2 emissions, not renewable energy. So I'm wondering if you include, I mean, you included a limit for water in this analysis. Did you include a limit for CO2 emissions consistent with the company's goal?
We do not constrain the model for a carbon reduction goal, but what we do is after we complete the modeling, we then go and evaluate the carbon emissions through 2030 and compare that to our 80% carbon reduction goal. And I believe in this case, we do meet the 80% goal of reducing carbon emissions from 25 million tons down to 5 million tons.
Okay, thank you. I just didn't see that represented anywhere, and just the confusion between reading Ms. Trammell's testimony and your testimony, it looked like no recognition of any carbon reduction requirement in the company's planning or analysis. So like, is that something that gets reported by the company where you're at in order to achieve your own goal?
The current levels are reported in the sustainability report. So I believe in 2022, we had reduced carbon emissions by either 52 or 53% from 2005 levels. So we're well on track to the 80% goal. Retiring taupe at the end of 2028 and a substantial build out of new renewable resources, again, will almost certainly get us to much, much closer, if not to our 80% goal.
Yeah, I guess the root of my question is your testimony, you make the case for how long it takes to get from planning to RFP to approval to resources online. It's 2023 right now, 2030 goal. If you don't have a plan to get to your own goal by 2030 now, how do you hope to achieve it?
Oh, I think our plan really centers around the New Mexico IRP process. As I believe it was Ms. Trammell, I may be incorrect, testified to, we were initially scheduled to file our IRP next year in 2024. We asked for a variance with the commission to file our IRP this year in October of 2023. When we file our IRP, we absolutely will be establishing our plan through the end of the decade to meet the New Mexico RPS standards, which we believe very much closely tied to our own company goal of 80% carbon reduction by 2030. So I think to your question, Mr. Chair, is we will file that plan in October the 15th of this year.
I look forward to seeing that, and then also an articulation of not just how you're going to meet your own goal, but how that meets the law with the reasonable and consistent reduction requirement. And then last question, if you go back to the stipulation, paragraph 16. So that paragraph requires that this current IRP will provide a forum for interested stakeholders to discuss timing of replacement resources to address retirement of taupe and other SPS system needs. So because that's in the STIP, it leads me to question, in the absence of that, would SPS deny stakeholders that forum?
Mr. Chair, I'm in the same position as you. I did not help formulate this STIP. It's my understanding, with or without this requirement, we would still absolutely involve stakeholder process per the IRP rules in New Mexico.
I appreciate that. Thank you. And that's it for me, Ms. Hearing Examiner.
Thank you. Chairman O'Connell. I don't believe that there were any other questions for Mr. Elsey. Ms. Hardy, any redirect? Any redirect, Miss Hardy?
Yes, Your Honor, I have really only one question on redirect.
Okay, go ahead.
Thank you. Mr. Elsey, in your opinion, will retiring Tolk in 2028 facilitate SPS's ability to make reasonable and consistent progress toward the zero carbon requirement of the ETA?
Yes, as I have testified to on several occasions, retiring Tolk at the end of 2028 will require a substantial build out of new resources, and SPS will acquire those resources in accordance with the Energy Transition Act and the Renewable Portfolio Standard.
Thank you. And then, Madam Examiner, the only other matter I wanted to raise was Mr. Elsey's verification of the bench response that he had provided, which was number 1-7, for which we did not have a verification.
Okay, so that was actually the commission bench request. You're referring to the bench request that I issued prior to the hearing?
That's correct.
Okay, let me. Can you see that, Mr. Elsey?
I cannot, no. I can now.
Okay. Do you see bench request number 1-7?
Yes.
And you see your answer? Okay. And this is true and correct to the best of your knowledge?
Yes, it is.
Okay, very well. Thank you for reminding me on that. Ms. Hardy? Any further redirect?
No further redirect, Your Honor.
Very well. Very well. Ms. Lynch had said it sounded like you had some questions based upon my questions, the chairman's questions.
Yes, I have only 3 questions.
Go ahead.
Thank you. Mr. Elsey, do you know when SPP first indicated a draft planning reserve margin increase?
Can you just be a little bit more specific? Are you talking about the current planning reserve margin?
Yes. When did SPP propose that there would be a planning reserve margin increase?
I don't recall the exact date. It was probably sometime last year.
Okay. And do you know if SPS explored the possibility for issuing an RFP for new storage or clean energy at that time to use for the reserve margin?
No, it would have been impossible to issue an RFP at late 2020, receive the results, evaluate the results, file CCN approval, and then build the resource before the planning reserve margin increase in the summer of 2023.
Has SPP considered using any clean energy or storage as a way to meet that reserve margin?
The Southwest Power Pool are not required to meet the planning reserve margin. They merely set the planning reserve margin.
Right, but did SPS explore meeting the need for that planning reserve margin by inclusion of more clean energy or renewable energy?
Again, SPS could not acquire new renewable or battery energy storage before 2023. However, SPS did issue an RFP in November of 2022, in which we will be procuring new renewable energy in order to meet the increased PRM after 2025.
Anything further, Ms. Lynch?
Yes. Could you also state what NOx costs were incurred by SPS in the last few years?
I do not know. That's not within my responsibility.
Do you know whose responsibility that is?
I do not know off the top of my head who is responsible for accounting for those costs.
Okay. Those are my questions. Thank you.
Thank you.
Thank you, Ms. Lynch. If we have no more questions, then Mr. Elsey?
Your Honor, I'm sorry. I had one redirect question.
Okay.
Based on Ms. Lynch's question.
I think that would be a re-read.
I think it is a redirect in response to the recross.
Okay.
Thank you.
Go ahead. I'll allow it.
Thank you. Mr. Elsey, is the Nichols extension that SPS has proposed the only viable option for SPS to meet in 2023 the increased planning reserve margin requirement?
Yes, I believe so.
And with respect, can I ask one more question, Madam Examiner?
Oh,
I know you said it was
no.
one. I've only got one more, I promise.
Go ahead.
Okay. With respect to the NOx allowances, Mr. Elsey, did SPS agree to not recover the 2022 and 2023 NOx expenses in the stipulation?
That is my understanding, even though I'm certainly not an expert on that subject.
Thank you. Those are all my questions.
All right. I think with that, Mr. Elsey, I don't believe that we have any more questions for you, and it's the end of the day. So your excuse, sir. Thank you very much. Have a good evening.
Thank you very much.
Do we have any procedural issues that we need to address before we recess for the evening?
Your Honor, would you like me to stipulate in the testimony of Mr. Ripperger, or would you like to do that in the morning?
Why don't we do that in the morning, and just so that we know what's going on. It looks like that under the current schedule, we'd be going to Mr. Lytle next. Is that right?
That's correct.
Okay, I have no questions for Mr. Lytle. I do not believe that no one reserved any cross-examination time for Mr. Lytle. So subject to me getting a directive that the commissioners have questions for Mr. Lytle, I will entertain having Mr. Lytle's testimony stipulated in. I'm also considering and have not made a determination. I believe after Mr. Lytle would be Mr. Dietenberger. Is that correct?
That is correct.
I'm also reviewing. I don't believe I have questions for Mr. Dietenberger, and potentially he could be, his testimony could be stipulated in if there's no commission questions. So it looks like to me that potentially we could be beginning with Mr. Lau. Is that that would be the next witness if Mr. Lytle and Mr. Dietenberger's testimonies were stipulated in, correct?
That's correct. That's correct, Your Honor.
Okay. So that's kind of the order then I'm thinking tomorrow. But of course, you know, we would want to have the testimony stipulated in and anything procedural before we actually begin the witness presentation. And then I think potentially we have already stipulated in the testimony of Mr. Shrube, DeSeelich, and that would bring us then to considering the testimony potentially of Ms. Doyle and Mr. Romer. Correct?
That is correct.
Okay. All right, very well. Those are the lineup that I'm thinking to begin tomorrow. And if anyone has anything else procedural, obviously we're not going to get finished with this case tomorrow, as I've already indicated to you. Due to a conflict that I have, we're not going to begin until 11 o'clock on Monday. And then potentially I can see completing potentially even tomorrow completing the witnesses for SPS. So I think that Occidental may want to consider having its witness, Ms. LeConte, available in the afternoon tomorrow, potentially, so that we can go ahead and begin the presentation of the other party's case. Additionally, subject to the commissioner's questions, just again as a trailer and I'm looking at potentially stipulating the testimony in of the LES FEA witness, Mr. Andrews, and then also potentially New Mexico large customer group witness, Bieber. So with that, I thank you all. And we are recessed until 9 o'clock tomorrow morning. Have a good evening.